Morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of proposed rules with regard to the Dodd-Frank Act. Today, I think we'll be considering 4 proposals and 1 advance notice of proposed rulemaking. The 4 proposals, I think we'll first hear from a panel with regard to protection of collateral of counterparties of uncleared swaps. These are the bilateral swaps that are between counterparties and swap dealers. This panel will also talk about a set of questions called an advance notice of proposed rulemaking with regard to similar protections, but with regard to the cleared swaps between counterparties, futures commission merchants, and clearinghouses. We will then hear on 3 proposals. I call them the data triplets or the transparency trio. But it will be 3 proposed rules with regard to 1 set of rulemakings on swap data repositories, 1 set of rulemakings with regard to the data elements and data that has to be kept by all various registrants, whether those be swap dealers or the swap data repositories themselves. And then I think last up in the dais will be proposals on real-time reporting. All 3 of these are critical. I think it was one of the key features of the Dodd-Frank Act to bring transparency both to the regulators, which the swap data repositories and the data elements are so critical so that regulators can have direct access and help ensure the integrity of markets and help police markets, but also to the public. And one of the key features of bringing transparency to the public is real-time reporting or post-trade transparency. We'll later take up, I hope in December, rules around swap execution facilities, and that's another feature of bringing transparency in the pre-trade transparency before the transactions. Before we hear from staff, I'd like to thank Commissioners Mike Dunn, Jill Summers, Bart Chilton, and Scott O'Malia. This is, I think, our 4th public meeting, and the team is just working terrific together. We are, I think, consistently sort of watching each other's backs and editing documents, and I do apologize to my fellow commissioners because sometimes those edits are coming in response to other commissioners' comments, but are coming in really in the last couple of days, and I know that we probably need to help each other's out by getting our edits in earlier, but this set of data rules had a lot of last edits in them, but it's really remarkable how hard each of the commissioners and their staffs, their legal assistants who you usually see sitting back here, I think most are here, but a couple aren't, are just working all the time. I also want to thank the staff of the whole commission with regard to these rules. I think that with today, if we do move forward with the proposals today, I think finally, Commissioner Summers, we're probably halfway there. I mean, I know the arithmetic seems odd, but with 2 final rules and 22 proposed rules, and I think this, if we move forward today, we'd have 4 advance notices of proposed rulemaking. So if I add up 4, 22, 2, that's about 28. I think that I'll give. That's probably at least halfway. But that's just the proposal stage, and as we've said in the past, we're trying. We set out a goal to do this through December. We have 3 more meetings in December. I think 1 has been officially calendared to the public December 1st, but we are looking for 2 additional dates. We do know of some matters that will be in January. We haven't set a date. We don't know if it will be 1 date or 2 dates in January yet. And, of course, I welcome the public to this meeting, and all of your comments on these proposals are just have already helped us tremendously, but will continue to help us in a formal context as the rules go out. I think today's rules are all for 60 days. I think the advance notice of proposed rulemaking may be 45 days. But the public comment will be very important. With that, before we turn to staff, I was going to turn to Commissioner Dunn.
Well, thank you, Mr. Chairman. I want to thank everyone for joining us today for this important meeting regarding the implementation of the Dodd-Frank Act. Today's meeting will address proposed rules regarding real-time reporting, data record keeping, swap data repositories, segregation, bankruptcy rules. As with previous proposed rules, I will support publishing today's rules in their current form, but reserve judgment on the final rules until I carefully review all the comments the agency receives from the public and get final recommendations from our staff. This, Mr. Chairman, is our fifth public meeting, not the fourth.
Thank you. My math is starting to slip. You can see how much I've been reading rule text.
I can understand. I empathize. This is our fifth public meeting to consider proposed rules pursuant to Dodd-Frank. And when I have a moment to actually reflect on the magnitude of the task before us and the speed at which we are moving forward, I am amazed. You've all heard the phrase, too big to fail, and just last week, Commissioner O'Malley coined the term, too costly to clear. My concern is whether we're moving too fast to follow. Our ambitious deadlines call for us to complete almost every rule Dodd-Frank requires by July 15th, 2011. However, the rest of the world is not working at this pace. At the 2009 Pittsburgh Summit, the G20 leaders declared that all standardized OTC derivatives contracts should be cleared through central counterparties by the end of 2012. Additionally, all over-the-counter derivatives contracts should be reported to trade repositories at that time. I think there is a fine line between leading the world on financial reform implementation and leaving the world behind. Since we are working at an appropriate pace for the circumstances as described by Dodd-Frank, it is imperative that we seek input and advice from our sister regulators around the globe throughout this rule-writing process. It's my understanding that CFTC rules team has been reaching out to and cooperating with international regulators in drafting these proposed rules. And it is my hope and expectation that our fellow regulators will continue to participate in the process of promulgating these important rules. It is also my hope that through this public process and with international cooperation, we will achieve final rules that ultimately will be in harmony with rules adopted by regulators internationally. I would also like to emphasize how helpful the various public roundtables have been in the process of drafting these proposed rules. The roundtable provides feedback that led to clear improvements in the rules that we are looking at today. Once again, I feel compelled to point out that the expense that will be involved in implementing these proposed regulations. To effectively implement the proposals, we will require substantial investment in new technology and human resources. If we are to achieve the goal of reducing the risk of future meltdowns, the CFTC requires funding at a level that provides for technology and staffing needed to do the job. I would once again like to thank the staff at the CFTC for all their hard work to getting us to the point we are today.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. I want to start by saying how much I appreciate all the work that the staff has done on these proposals today. And I think, as I said last week, as we continue this process, the rules are becoming much more complicated and comprehensive. And so your staff work and all the teams that are responsible for what's in front of us today, hundreds and hundreds of pages of these proposals. I just want to say how much I appreciate everything that you have done up until the very last minute, making changes and accepting comments on these proposals. I do have a number of concerns with regard to a couple of the items that are on our agenda today, and I think that my concerns are both substantive and also with regard to the process that we're in. And because of these tight statutory deadlines and trying to get all of this done by the dates that we're required to do it, as Commissioner Dunn said, that people are having trouble following what we're doing. I might be having trouble following what we're doing. It's a lot to keep up with. So I would say that I'm not sure that this process is sustainable. Through finalizing some of these rules, we're putting out proposals, we're hoping for public comment, and appreciate everybody who is participating in this process. But as we continue on trying to finalize some of these rules, I think that this process may be unsustainable. I want to say thank you to my staff for doing an incredible job and helping me keep up with all of this, and also to agree with Mike on the coordination with the SEC and with other foreign regulators. I think it's key with the proposals that we're putting out today, considering the SEC is doing some of the exact same issues today, to make sure that we're consistent with what the SEC is doing, and to really talk about and deliberate how important that is. Is it important for our rules that we put out today to be almost identical to what the SEC is doing, or do we need to just try to be consistent with regard to the markets that we're each regulating? I guess I'll end there and say how grateful again I am to the staff, and I look forward to your presentations today.
Thank you, Commissioner Summers. I was just, as both Commissioner Dunn and Commissioner Summers have raised, coordination for the public to hear, because I know all the commissioners know. We've been sharing staff-to-staff information with the SEC and the Federal Reserve, various bank regulators here, where appropriate, the Treasury Department, and then international regulators. And this is primarily in Europe, but also in Asia and Canada and so forth. And this includes sharing internal memos, internal term sheets, as the term sheets were developed through September, and then more recently, actually, the proposed rule text. And while the comments come very specifically from our fellow regulators in the U.S., it's actually been very positive. The European Commission, the FSA, which is the London lead regulator, the European Central Bank, a committee that has security dealers in Europe, CSER, have all commented. And where possible, we've tried to accommodate their comments. But ultimately, it's the five of us up here that have to, have the statutory mandate, and the President appointed us, to do this. So we take in those comments, but I do think we're trying to be as consistent as possible, but there will be some differences with even the Securities and Exchange Commission. I think somebody's keeping account of meetings, but I think we're up over 250 meetings with other regulators. That compares to probably over 400 meetings with the public, so I don't know how to judge that, but and I agree with you all that the statutory deadlines are demanding, but I think they also help to lower regulatory uncertainty. And of course, these are just proposals. So if we do need the public's comments to sort of help us, and that's why that probably thousands, maybe tens of thousands of comments we'll get in the spring will have to be sorted through very thoughtfully before we go to final rules. I agree with that. But Commissioner Chilton.
Yeah, I agree. I mean, it's difficult but doable. I was just thinking this week, seeing all the meetings, people running in and out, sort of like a beehive here, into our offices, and groups of some of you moving large groups from one place to another. And I thought, it's rule writing on steroids. And but that process is a tested process. Whether or not it's tested with this many rules at this level, we don't know. But I think it's challenging for a lot of people and a lot of folks that have been coming and visiting us. And challenging may be a real understatement. Some people sort of freaked out, and some people are scared, and maybe legitimately so, and some of them are sort of panicky. They don't know what's going to happen. Is the government going to help me out of business? And, well, I understand that, but when people panic, a lot of times they sort of want to head for the door, or how do we get around this, or how do we get out? And a lot of people have done that, too. They've talked about how they get out of this. They've talked about why they are different. remember Church Lady from Saturday Night Live? She'd say, "Isn't that special?" And how convenient. Well, a lot of people are special. And they actually are. Some of them really are special. So it's good that they've been coming in and letting us know. And what I've been getting caught up in sort of this beehive of activity, I've thought, well, geez, we don't want to do any harm, and we don't want to mess up things that are going on well. But then you sort of step back and say, wait a minute, how do we get here? We had the regulatory environment in which we had the economic calamity. The regulated futures market has worked very well. I mean, Jim Newsom did a hell of a job. The regulated stuff works well, but that's $5 trillion annualized trading. And the OTC is $600 trillion. And a lot of that worked well. A lot of the unregulated stuff worked well. But there's a humongous section that hadn't worked so well. And that's where CDSs were, and that's where AIG was, and that's what helped the economy go down. And when you talk about doing no harm, there's a hell of a lot of harm that's already been done on families and businesses. And people are, all of our pensions are worth half. Our college funds for kids are worth less. So there's already a lot of harm done. So how do you figure this all out? And I'm just thinking I needed to step back. Got all these meetings. Everybody's freaked out. All right, there's a singularity of purpose for us. We've got the law to go to. As much as we'd like to do this or that, we got to go back to the law. Now, there's some flexibility. Dan Berkovitz and I, the chairman, have talked about. There's some flexibility, but there's also a lot of things that you can't defer, or delay. There are things that are set in stone, and that's where we have to go. Even if we didn't like it, that's what we have to do. So that's what I want to do. Do what the law says. Now, the last point is that this is a pretty tough time because there's all these moving pieces that Commissioner Summers was talked about, and the reams of paper. And so it's disconcerting because folks don't know what's going to happen. But as we're putting these pieces, like we are today, of the puzzle, people are starting to get a visual of what's going to happen in the future. And they'll know where they're going to be. And so I think once we get these out, and hopefully most of them will be out in the very near future, people cannot be as freaked out, cannot be as concerned, and hopefully we'll take all these comments, and I hope that people that have been here have felt like we've taken their comments in. I know I have. I know some of my commissioners have been working, my fellow commissioners have been working on this with changes. We're actually learning from folks who are coming in. So blanket thank you, like everybody else has, not just to the staffs, the chairman, but to everybody that's come in. It's been very helpful. I'm confident that this is difficult, it's challenging, but it's eminently doable. Thanks.
Thank you, Commissioner Chilton. Commissioner Amalia.
Thank you, Mr. Chairman. Again, let me add my voice to the chorus, thanking the teams. We have Bob Wasserman and his team, Susan Nathan, Jeffrey Burns and their teams, David Taylor and his teams, and Tom Leahy and his team for all their hard work on these respective rulemakings. Mr. Chairman, I'm well aware of how passionate you are about real-time reporting and your desire to bring greater transparency to the swaps market. However, the real-time reporting rulemaking reminds me of what a comment by President Teddy Roosevelt. He once said, in any moment of a decision, the best thing you can do is the right thing, the next best thing is the wrong thing, and the worst thing you can do is nothing. Well, I'm quite confident we are not doing the latter. I'm not quite convinced we're doing the best thing either. By mandating a 15-minute reporting on blocks of trades and large notional swaps between dealers and end users, while providing little direction on the reporting of all remaining trades. I believe we owe the market some certainty as to what the Commission believes is technically practicable. If the Commission does not know, then we should admit as much and attempt to identify an outer time reporting boundary that provides a clear, safe harbor for the market to conduct its business. As I noted at the last rulemaking, it's difficult to define the terms and conditions of a post-trade reporting regime without the benefit of the proposal on the mode and the manner in which swaps will be executed. I hope that we will be presented with a SEF definition that will enable the market to transact on a range of electronic platforms that will not only increase transparency but will lead to more standard products, as you have strongly advocated. A second concern I have with the real-time reporting rules is that it fails to take into account the Dodd-Frank Act statutory mandate to consider liquidity and the material impact that reporting may have. Unlike the futures market, the swaps market is comprised of a diverse set of products that trades infrequently and are larger in notional value compared to the futures markets. The swaps market also has far fewer participants. Congress clearly recognized that there are key differences between these two markets and expects us to do our homework and understand the relationship between post-trade reporting and liquidity. I have some concern about a footnote in the rulemaking preamble with regard to this rulemaking that admits that there is a lack of public information regarding the market liquidity, how market liquidity might be impacted by the post-trade reporting. Specifically, footnote number 74 states, the Commission expects that as post-trade transparency is implemented in the context of the Dodd-Frank Act, new data will come to light that will inform the discussion and could cause subsequent revision of the proposed regulation. I find this shoot first, ask questions later approach to be problematic, and I cannot support this rulemaking. Mr. Chairman, the data and record-keeping rulemaking I have a far more favorable view of and is a very important document. It does not hide from the fact that we don't know how the collection, the retention, and the utilization of data will play out in the swaps market. The rule provides over 75 requests for comment, and I believe this approach is appropriate. And I, too, have numerous questions as to how the Commission's own technological capabilities will be implemented. I'm interested to know if the rulemaking team has given any thought as to the necessary infrastructure investments the CFTC will need to make in order to fill the numerous regulatory responsibilities created by this proposed rule. One important element of this rule is the requirement to establish a unique identifier for every swap transaction, and market participant. I'm eager to receive comment on this provision. While I believe the policy rationale underlying the requirement is sound, I do recognize that the cost burden of an ID is high and the impact on data storage is significant. However, I understand that the domestic and international communities are very eager to adopt such a concept, and there is no better time than to implement it from the beginning. In addition, I believe the rulemaking is sufficiently complex that I would not be opposed to extending the 60-day timeline to enable for the public to comment on the 75 requests for comment in this rulemaking. The focus on today's discussion on trade reporting, storage, and analysis begs the question as how the Commission is preparing to handle our greatly expanded mission. Mr. Chairman, as you are well aware of my strong desire to reorganize the Office of Information and Technology Services in order to establish an Office of Market Data Collection and Analysis. This entity will clarify the Commission's technology needs and support the Division's surveillance requirements. With regard to the segregation and bankruptcy rule, I have great concerns with this issue, and I'm pleased the Commission is taking a prudent step to put out an advance notice of proposed rulemaking on this complex issue. This will benefit certainly from public input. On November 3rd, I sent out a letter to a number of end-user groups on the manufacturing, energy, and agriculture sectors asking for comment on the costs associated with individual segregation and the possible creation of a bifurcated system. I received a range of comments, all of which will be posted on the website, and from those who support it and those who strongly oppose it. And it is clear there is not a consensus among those who stand to be significantly impacted by this rule, and we must be cognizant of the diverse opinions that will not be resolved without public input. And I'm very interested to learn what other options we are going to consider, and I know that's included in this rulemaking. I also have concerns about the impact the different proposals may have on risk management practices of future commission merchants that handle swaps under this new regime. It is my understanding that it has not only been a longstanding industry practice for designated clearing organizations not to treat FCM customer funds held collectively in an omnibus account as the property of a particular customer, but also that FCMs and DCOs have long relied on a commission guidance contained in interpretive statement number 85-3. As a result, if the FCM customer is unable to make a margin call and the FCM defaults, regardless of the customer's inability to make margin call resulting in the default, a DCO may recover margin owed from the FCM's collective omnibus account. If we propose to move away from our prior guidance and treat segregated customer funds for cleared swaps differently than how we treat futures commissions funds that have been handled thus far today, we should consider the rationale for doing so. I think it's important that the public is aware of the Commission's prior guidance on this issue as they develop their comments, and I ask that a copy of the interpretation be included in the rulemaking to be published in the Federal Register. I think that'll add to the guidance, and maybe you'll consider that. Mr. Chairman, in closing, I recognize that we still have a great deal of work ahead of us, and we try to do the best thing to get these proposals right, as all of my colleagues have indicated thus far. And it is in the interest of providing meaningful debate. Let me renew request to move those entity definitions at the next rulemaking, which I think we're prepared to do. And with regard to the SEF definition, if we cannot get that on the next at the next meeting, I wouldn't be opposed to extending the deadline for real-time reporting in order to make sure that we have the real-time reporting in the SEF in front of the public, and so they can compare them side by side to understand how they're going to transact and how they'll report. I also renew my request for a staff roundtable on capital and margin. And let me finally just thank again the teams that have worked so hard on these rulemakings. I appreciate you considering our input at a very late date, and the chairman's as well.
Thank you very much, Commissioner Amalia, and I thank all of the commissioners for their very thoughtful comments in these opening remarks. I think after we go through the...
Mr. Chairman, if I could,
sure.
because there were a number of things that were brought up here, and we are under a difficult timeline, and that's mandated by Congress, and we've all sworn to uphold the law, and that's what you're trying to get us to do. It's a little like herding cats. I understand that. I was at a seminar at the Stern School of Business on Wednesday. Rob Engel, who is on our joint advisory group with the SEC, was there and asked us how we were doing. I said, well, we're proceeding, and he said, good, and they're standing by to help us. But I did get questions very similar to what was raised here by the commissioners, and one of the things that I'm thoroughly convinced of is that the financial industry would like us to have some legal certainty there. They have spent a couple of years going through the Dodd-Frank Act, and they've all went in and they did their give and take on that. They know what the Act says, and that Congress, in their wisdom, allowed the commissions, SEC, CFTC, Fed, Treasury, the leeway to make some decisions in there. And I think it's important because things change, and what we do as we develop these regulations change, and they're going to have impact on that whole financial industry that we oversee collectively. I'd like to remind people that rulemaking is much easier than legislating, and that what Congress did when they developed the Administrative Procedure Act, in my opinion, was one of the best things that Congress has ever done, because it set out a process of how we operate. But regulations are dynamic. They're not static. And we are going to make mistakes in what we come up with. We can't do anything this magnitude. But we have the luxury under that Administrative Act for people to petition us to change those regulations if we do get it wrong. Not saying we're going to get it all wrong. I hope we're 99% there. But getting that legal certainty out there, letting people get on to understand what the rules are so they can continue in their business, in my opinion, is extremely important as we go through this uncertainty that has surrounded the financial industry in the last couple of years. And so there are a lot of warts as we go through the process, but I think at the end of the day, we get to do plastic surgery on those, and we will have an opportunity to get it right. Maybe not this commission, but future commissions will get those petitions if there's something gone wrong, and that'll get corrected. And it's an ongoing process. There will, as we do things, it has an impact on that financial service environment, and that in itself will make for changes that have to take place. So at the end of the day, I want to get forward with the process. I want to get these proposed rules out to get down to the hard and fast situation of making those final rules out there. But even final rules are not final. you still are going to have opportunities to make changes.
Thank you, Commissioner Dunn. I again, thanking everybody. I was going to turn to the teams, but after we go through each of these, and I know we have a large agenda, I was going to comment just on the next three meetings and what we might also be seeing in January. So if I can, Commissioner O'Malley, if I can sort of respond to some of, because I think we've chatted privately, and I think we're pretty much aligned, maybe with one exception in there, but if we can do that whole scheduling part at the end after we do that, then if that's all right. I'd like to, I think now, begin with the presentation and discussion on a notice of proposed rulemaking and an advance notice of proposed rulemaking, and I'm going to leave it to the team here in front of me to how you discuss both, but we will have to have two votes and two motions and things like that. But what's really being discussed here is with regard to the protection of customer funds, whether it's in the customized or bilateral world where a swap dealer is holding those funds or margins that might be posted, and how that's protected in segregation and bankruptcy, or where we're going to be asking further public input in this advance notice, hopefully, or at least staff is recommending it on the cleared spots. Anada Radhakrishnan runs our Division of Clearing and Intermediate Oversight. Robert, or Bob Wasserman, the ever-present member of the team, but he is the team lead on these issues of segregation and bankruptcy. Martin White from the Office of General Counsel, who has researched not only 85.3, but all sorts of matters on clearing back to 1938. I've been reading some of your memos, Martin. And then Dan Berkovitz, our General Counsel. So I hand it over to you.
Thank you, Mr. Chairman. I'm Bob Wasserman of the Division of Clearing and Intermediate Oversight, and as you mentioned, I'm the lead for the segregation and bankruptcy team. I would like to express my appreciation to all of the other members of the team, Martin White sitting next to me of the Office of General Counsel, my DCIO colleagues Nancy Schnabel, Jennifer Bauer, and John DeBoard, and of the Office of Chief Economist Dave Riffin and Todd Prono. I'm presenting two documents today: a notice of proposed rulemaking concerning protection of collateral of counterparties to uncleared swaps, which also addresses a number of housekeeping matters that I'll describe later, and then an advance notice of proposed rulemaking and a request for comment concerning protection of cleared swaps customers before and after commodity broker bankruptcies. With respect to the notice of proposed rulemaking concerning protection of collateral of counterparties to uncleared swaps, in Section 724C of Dodd-Frank, which is codified as new Section 4S(L) of the Commodity Exchange Act, Congress enacted provisions to require swap dealers and major swap participants to notify their counterparties of what the statute describes as a right to require segregation of property margining the obligations of those counterparties. The use of the term right to describe what would otherwise be a term for commercial negotiation suggests that Congress thought that segregation of margin is important. However, the terms of the statute make it clear that a counterparty may elect to require segregation, but also may elect not to require segregation. For example, Section 4S(L)(4) deals with reporting requirements where a counterparty does not choose to require segregation. Moreover, I see no impediment in the statute to a swap dealer offering different terms depending upon whether the counterparty elects segregation or not. In order to enhance the likelihood that this important decision will be addressed at an appropriate level, proposed Regulation 23.601 requires that notice be delivered to the Chief Risk Officer of a counterparty, or, if there is no such officer, to the CEO or the highest level decision maker at the counterparty. And while the statute may be read to require such notification at the beginning of each swap, the rule provides that notification of a particular counterparty by a particular swap dealer or MSP need only be made once in any calendar year. A counterparty may change its election at any time upon delivery of written notice, but that change would only be effective with respect to swaps entered into between the parties after the delivery of that notice. Now, the statute states that this right does not apply to variation margin. Accordingly, Regulation 23.600 defines both variation and initial margin, delineating between the two based on time. Variation margin covers current exposures arising from past changes in the market value of a position, while initial margin is based on anticipated exposure to future changes in the value of a swap. The regulation sets forth requirements where the counterparty elects to segregate. Proposed Regulation 23.602 would require that initial margin be segregated with a custodian that is independent of both the swap dealer or major swap participant and the counterparty, although an affiliate of either party would be eligible under the proposed regulation. The rule as proposed leaves the choice of independent custodian to negotiation between the parties, but we explicitly ask for comment on whether one party or the other should be granted that choice, and if so, what criteria should be applied. Regulation 23.602 also sets forth requirements for the custody agreement. The agreement must be in writing and must include the custodian as a party. The regulation also requires clarity in the agreement concerning when either party may obtain control over the margin in accordance with the agreement between the parties in order to avoid expensive and time-consuming interpleader proceedings, which is what would happen if the custodian is faced with a situation where there is no clear answer. It also requires that the turnover of control must happen with a statement in writing from an authorized representative of the party seeking such control made under penalty of perjury. Regulation 23.603 governs investment of segregated collateral, limiting such investments to those permitted under Regulation 1.25, which is the standard the Commission applies to customer funds posted as collateral for exchange-traded futures. I should note that the regulation we are discussing here only governs investments of margin that is posted by a counterparty and does not govern what collateral is eligible to be posted as such margin. As required by the statute, the regulation provides that the swap dealer and counterparty may enter into any commercial arrangement in writing regarding the investment of segregated initial margin and the related allocation of gains and losses resulting from that investment. The proposed effective date for those rules is 6 months after promulgation of final rules, and we request comment as to whether that period is sufficient. This notice of proposed rulemaking also addresses two housekeeping matters. First, Section 713C of Dodd-Frank requires the Commission to exercise its authority to ensure that securities held in a portfolio margining account, carried as a futures account, are customer property, and that the owners of those accounts are customers for purposes of the commodity broker provisions of the Bankruptcy Code. This provision is implemented through amendments to Part 190, the Commission's bankruptcy regulations, concerning the definitions of customer and customer property. Second, and outside of Dodd-Frank, the Statutory Time Periods Amendments Act of 2009 changed, among other things, one of the time periods in the commodity broker section of the Bankruptcy Code from 5 business days to 7 calendar days. This rulemaking changes the Commission's Part 190 bankruptcy regulations to conform to that change. I would now like to turn to the advance notice of proposed rulemaking and request for comment concerning protection of cleared swaps customers before and after commodity broker bankruptcies.
I just asked, it's up to you, but since we're going to vote on these separately, do you want to take them
That would be great.
separately?
I think we should take them separately.
Okay. So I think I'll entertain a motion on the staff recommendation on the notice of proposed rulemaking on segregation and bankruptcy matters for uncleared swaps.
So moved.
Second.
Having been moved and seconded, we'll talk about it a little bit. I support the proposed rulemaking concerning protection of collateral and of the counterparties to these uncleared swaps. I think the proposal does include important protections for end users when entering into bilateral or what I'll call customized swaps. The proposal follows the congressional direction to allow end users to have a choice if they so decide to have it segregated. The initial margin, this is segregated and posted with a third-party custodian. And I think these are important protections for users of swaps, whether they be corporations, whether they be pension funds, whether they be asset managers. The proposal includes also the necessary housekeeping details that Bob Wasserman so kindly took us through about sections 190 and other parts with regard to that. So I'm just going to say that I support it, but I don't have any questions for you. Commissioner Dunn.
Mr. Chairman, I have no questions on this as well. I just want to point out that both this and the advance notice of proposed rulemaking were the subject of a roundtable meeting that the staff had at the request of the commissioners, and I think it vastly improved both pieces of regulation that we're looking at today. And in that same vein, I would support Commissioner O'Malley's request for roundtable meeting on other issues.
Though I said I'd reserve earlier till later, I think I've told you each probably privately I support this capital margin roundtable. But Commissioner Summers.
I don't have any questions.
Commissioner Chilton.
I have one, and thank you all for your work. I know it's been a tough one. We got a letter we got one letter, one of these comments letters, and it talks about these tri-party agreements. I'm just going to quote from the letter. It says the Commission should seek the views of the buy-side participants on the use of tri-party custody arrangements for both initial and variation margin to mitigate risk in the swap market and the effect on their participation in the cleared swaps market if they are not permitted to use tri-party custody agreements, as is common in the over-the-counter market. Could you discuss whether or not this rule impacts that, or whether or not this would forestall anything with regard to that in the future?
It certainly would not forestall anything. Actually, what it does is, with respect to initial margin. I'm sorry?
Be a different rule, different proposal, perhaps? In a different proposal?
No. Actually, what this proposal does with respect to initial margin is that it provides, as the statute requires, that the counterparty be given the right to elect whether to require segregation or not. If they elect to require segregation, it requires a tri-party agreement, essentially between the counterparty, the swap dealer, and the custodian. Now, the statute was very clear that this right only applies, as a right, applies only to initial margin. And so it does not grant the right for variation margin because that's what Congress decided. Having said that, if the parties decide to also segregate variation margin, they could put that in the same account with the initial margin, and the proposed regulation explicitly permits that.
And there is nothing, if the Commission at some point decided to do something else, we wouldn't be forestalled. There's enough language here to hook that you wouldn't be coming to us and saying, well, you know, that thing that you asked might be a good idea, but we can't do it because of how we wrote the proposal. We retain our flexibility in this rule if we want to do something. And I'm not suggesting where we'd come out. I don't know where I am. But I want to make sure we're not forestalling the ability to do something.
No, we're not forestalling anything here.
Okay.
We don't allow the use of tri-party custody agreements in cleared contexts because the concern is the FCM must have an unfettered right to customer margin. And if you have a third party involved, the bank can say no. Somebody can slap an order on the bank saying don't release the money, and that's why we've been very uncomfortable with tri-party agreements, because the concern is any time that the FCM needs to get customer margin to pay to the clearinghouse, it should have an unfettered right, and that's I think that's what they're talking about. So.
Okay. Thank you both.
But your answer was uncleared in bilateral space.
That's how we allow, as Bob pointed out, we allow tri-party.
I see. Thank you, Commissioner Chilton. Commissioner May. Not hearing any further questions, I will, call the voice vote. All in favor say aye.
Aye.
Any opposed? The ayes appearing to have it. The ayes have it. Bob, if you want to chat about the advance notice.
Thank you. Yes. Section 724A of Dodd-Frank requires segregation of swaps customer funds in the cleared environment. And 724B addresses the bankruptcy treatment of cleared swaps. To implement these provisions, the Commission will ultimately need to propose regulations. What makes this issue tricky is something that can be described as fellow customer risk. Under the futures model for protection of futures customer
You called it
funds.
fellow customer risk?
Yes.
Thank you.
Under the futures model for protection of futures customer funds that has been in use for decades, customer funds are protected on an omnibus basis. Customer assets are segregated from the FCM's own assets and liabilities, and creditors of the FCM cannot attach customer funds. However, FCMs post collateral to clearing organizations on an omnibus basis. That is, a clearinghouse will have one account for all of an FCM's futures customers, and the clearinghouse legally has no knowledge of or relationship to any individual futures customer. They may, on a practical basis, have such knowledge for risk management purposes, but on a legal basis, they have no such knowledge. If a customer defaults to the FCM with respect to losses on futures contracts, it is the responsibility of the FCM to make good the loss from its own capital, to avoid permitting the funds of one futures customer being used to margin another customer's contracts. And in fact, I'm sure every day there are defaults by customers to FCMs, which are made good by the FCM. However, if a customer loss exceeds the FCM's available capital, then the FCM will default to the clearing organization. And the clearinghouse will use all of the collateral posted by the FCM on behalf of its customers, including collateral attributable, in fact, to non-defaulting customers. In the commodity broker bankruptcy that would follow, all of the FCM's futures customers, not just those who may have been dealing with contracts cleared by that clearinghouse, but all of those customers, would share proportionately in those losses. And as has been discussed, we've had extensive consultations with a variety of stakeholders on these issues, including customers, futures commission merchants, and derivatives clearing organizations. These consultations took place at bilateral meetings reflected on the Commission's website and at the October 22nd staff roundtable. Some swaps customers, many of whom are used to successfully negotiating for segregation of collateral they currently post for uncleared swaps, as was mentioned, are concerned that in a cleared swaps environment, they will be exposed to those risks posed by their fellow customers. They note they will be required to clear many swaps and ask why they should be exposed to a new risk, which is largely out of their control as part of that move to clearing. Firms and clearing organizations express concerns about the costs of protecting customers individually. They note that certain models of individual customer protection have extremely high administrative costs in terms of day-to-day compliance, and others create significant costs due to changes in the risk environment. And some of those costs have, some of those concerns have also been expressed by customers, as you note. As to that risk environment, clearing organizations use a variety of resources in addressing potential FCM member defaults arising from a member's customer account. These resources, which are frequently referred to as a waterfall, typically include, in order, the property of the defaulting member, the margin posted on behalf of all of that member's customers, a portion of the capital of the derivatives clearing organization, and the default fund contributions of other members of the derivatives clearing organization. If the collateral of non-defaulting swaps customers of an FCM is not available as a default resources, clearing organizations will need to change their models for sizing their default waterfalls and or the size of the components of those default waterfalls. One means to do this would be to increase margin levels. And at the roundtable, one clearing organization estimated that it might need to increase collateral from a 99% confidence level to a 99.99% confidence level, which would cause an increase in required collateral for each customer of approximately 60%. Those increases in required margin levels would be passed on to customers, as an FCM is required to collect margin from a customer at a level no less than the margin the clearinghouse collects from members. An alternative approach to meeting this challenge would be to increase clearing members' default fund contributions. FCMs note, however, that if they're required to commit added capital to clearing by making these increased default fund contributions, they would pass those costs on to customers. As I said, some customers have expressed concerns about these costs as well. We've heard a number of fairly rough estimates of these costs, but have not yet obtained from anyone a really thorough and detailed analysis. Staff is accordingly recommending that the Commission publish an advance notice of proposed rulemaking and a request for comment to obtain information that we and the Commission can use to analyze these very important issues of cost. The proposed notice suggests 4 models for customer protection: the existing futures omnibus model and 3 alternatives. We ask a detailed set of questions, endeavoring to tease out the details of the costs of each model relative to that existing omnibus model. The first alternative model we describe is full physical segregation, where each customer's property would be kept separate and treated separately from every other customer's property at each level of the process, at the FCM, at the clearing organization, and at each depository. A second alternative model is legal segregation with commingling. In this model, the collateral of all customers can be kept on an omnibus basis, but will be attributed to each customer based on the collateral requirements set by the clearinghouse for that customer's positions. Staff believes that this model significantly reduces administrative costs, but may well involve risk costs. And I should note, while that is what staff believes, again, our hope is to get more detailed comments from the folks out there in the industry to essentially detail the costs. The third alternative can be referred to as moving customers to the back of the waterfall. This model is similar to the second model in that customers are treated individually, but it's different in that the clearing organization may continue to rely on the remaining collateral of the non-defaulting customers as a default resource. However, the clearing organization would be required first to apply its own contribution to default resources and the entire guarantee fund contributions of non-defaulting members. And so the customers essentially would be moved from more of a frontline exposure to very much at the end of the line exposure. That model would leave the collateral of non-defaulting customers somewhat at risk, but only in the most extreme of circumstances. That is, in a default which consumes the entire guarantee fund. That, however, permitting the contributions of non-defaulting customers to remain as part of the available resources may result in minimizing the risk costs. We then have a detailed set of questions addressed to each stakeholder group, seeking comment on the cost of each alternative model compared to the futures omnibus model. First, we ask customers about costs and benefits from their perspective. Next, we ask firms about the differences in their activities that would result from each model, about estimates in an initial and annualized ongoing cost for those incremental activities, and about how those estimates could be applied industry-wide. We ask about incremental costs from changes in the risk environment, whether those costs are the same for each member or are a function of activity level, and how those estimates can be applied industry-wide. Then we ask clearing organizations about their incremental activities and costs and for their views on how costs would change for their members. In particular, we ask about changes to their default management structure and the costs imposed by those changes on the clearing organization and on its members. We ask all commenters for comments on optional models, that is, models where customers could choose between omnibus collateral protection or individual collateral protection. How could costs be attributed to and charged to those customers who opt in? How could those payments be used to address those costs? In particular, how much cost would be avoidable in an optional model? And what changes would we need to make in our bankruptcy approach to accommodate an optional model? We also ask questions about how customers can, under the base model, because this is a suggestion a number of folks have made, well, how can customers risk manage their FCMs? That is, provide market discipline by doing businesses with FCMs that pose less risk. To what extent would each alternative model lead to moral hazard concerns? Also, what information would each customer need to effectively manage the risk posed by fellow customers? What is or would be the cost per customer of conducting this risk management? And how does that cost translate to the industry as a whole? We hope that commenters will provide detailed answers to these questions, and I'd like to thank you for the opportunity to describe these releases.
Thank you, Bob. Do I hear a motion on the staff recommendation to publish an advance notice of proposed rulemaking on cleared segregation?
So moved.
Second.
And now we'll be chatting about it, but I think the first thing I was going to do is to ask unanimous consent to take up Commissioner Amalia's suggestion of including 85.3 with a short question, so it would add a question, and I'll just roughly read it. It's sort of written here. But that we'd ask commenters' views on 85.3 and how it should inform the rulemaking on this, I don't know what we call this topic, but the rulemaking on swap segregation.
I greatly appreciate your willingness to do that, and I support it.
Yeah, so I ask unanimous consent. Not hearing any objection, or are there any objections? I think the parliamentarian would tell me to say. Not hearing any objection, that passed by unanimous consent. I support the advance notice of proposed rulemaking concerning protection of collateral of customer funds. I will have a couple of questions, but let me say why I in support here. I think there's been much public input on this, and I do thank the public and the staff for holding this really very good roundtable in October. But I think it's appropriate to kind of formalize and get this public comment in a file and in a way and solicit input. And I'm hopeful this input comes from a broad spectrum. We've heard from a lot of pension funds and asset managers who I think generally, not always, but generally would like more individual protections. We've heard from futures commission merchants and clearinghouses that generally, not always, have been sort of on the other side. And I think this is a very complicated matter, and I'm very pleased that we're going to move forward and have an advance notice of proposed rulemaking and hear from the public. I just wanted to ask two questions, though, and I'm glad Commissioner Malia suggested about this 85.3, but I have a question probably for General Counsel Berkowitz, but anyone at the table. I understand that the statutory provisions for swaps clearing are almost the same as in futures clearing, but have a difference. And could you just describe, any difference between the statutory provision of the two? And they might be slight, but if you could help us out.
Excuse me, that's correct, Mr. Chairman. The statutory provision governing the clearing of futures contracts, which has been in the statute since, the original provisions were in the Commodity Exchange Act, but the provision I'm going to quote was added in the 1968 amendments, and that's 4 no paren D, paren B of the Commodity Exchange Act, which basically states it shall be unlawful for any person, including but not limited to any clearing organization, that has received margin, basically margin funds, that is held in a segregated account, to hold, dispose of, or use any such money, securities, or property as belonging to the depositing futures commission merchant or any person other than the customers of such futures commission merchant. So it says you can't use the customer money that's deposited in these accounts as belonging to the FCM or any person other than the customers of such futures commission merchant.
So that's what's in our current law that was added by statute in 1968, and that's for futures.
That's correct.
And so what is it for swaps?
For swaps, the Dodd-Frank added to the Commodity Exchange Act 4 no paren D, paren F, paren 6, which is virtually identical to the futures provision, but the final clause relevant here prohibits the use of those funds by similar persons or treating it as belonging to the depositing futures commission merchant or any person other than the swap's customer of the futures commission merchant. So it refers to swap's customer in the singular, the provision added by Dodd-Frank, where by the existing provision in the Commodity Exchange Act refers to swap's customers in the plural, the difference between singular and plural in the word customers.
So largely the same, but in the swaps world, in the futures world, the 1968 provision talks about segregation and protection of customers with an S, and then the swaps customer without an S.
Correct.
Well, I'm assuming we'll hear from commenters through the advance notice of proposed rulemaking on that. My other question is, as I understand it, maybe way back from the 1930s, the funds are not supposed to be commingled except for convenience. Can you tell me what you think the word convenience means? And I promise it's my last question, but...
Generally, the Commission has interpreted the words convenience generally to mean for administrative convenience, for how do you keep track of these funds for accounting convenience, administrative convenience.
Commissioner Dunn?
So it does not mean the convenience of the customer.
And the convenience of the FCM.
Just one quick question on the timing of this, because this is an ANPR, and you've thrown out 4 different models here, and you're asking for within 45 days folks to comment on those models. What do you envision as staff reviewing those and the timing of coming out with a proposed regulation, if that's what we end up at the end of the day, would be?
I expect that when we get these comments in, we are going to very quickly and diligently look at them, and I rather expect we may try and do follow-up depending upon the clarity of the comments, depending upon the questions the comments themselves raise. And I would expect within a period of, I'm going to guess, a month is probably about as much as I'll be able to get, to essentially do follow-up and essentially try and study this issue so that we can essentially move to recommend a proposal.
Sorry, I had an angel talking on my shoulder here.
Hopefully you're a better angel.
There was talk about getting some type of a study on going through, and this is in lieu of that study, I guess, or you don't envision staff doing any studying, doing a study that go out for peer review or things like that during this process?
We could do a study, but it had to be quick because we have to propose a rule for cleared swaps, because right now there is no rule of cleared swaps. So it'll have to be a very aggressive study.
It then occurs to me that for us to get one of the models that makes the most sense for all individuals involved, that comments that are jointly submitted then by a number of different entities that have a dog in the fight may go a long way in giving us the direction we might be going to.
That might be the case. I mean, if you look at the round table, the firms and the DCOs are pretty much on one side, and some of the MFA was on the side of individual SEG. A guy from BlackRock was on the side of individual SEG, and some other mutual fund was on the side of individual SEG. So you're right. It's basically you've got a group of people who want individual SEG, and the industry right now is saying, it's going to be very costly and so on. So And I guess the issue is, at the end of the day, you just cannot do it for swaps and not do it for futures because you'll have to change all the system. It doesn't make any sense. So practically, if the industry is going to change it, it'll have to change it for both swaps and futures.
My point being that if those various interest groups could get together during that 45-day period and say, here is a solution, preferred solution, although it doesn't give everybody 100% what they want, staff would look favorably on that.
Absolutely. I think if the industry came up with a solution jointly, I think certainly they will look upon it with a lot, assuming that it makes sense. And the other thing we've got to consider the bankruptcy implications, because depending on what they propose, staff may have to propose further amendments to our bankruptcy rules. Well, assuming it doesn't conflict with the code. Let's assume that. But if it doesn't conflict with the code, then staff may have to propose changes to the our bankruptcy rules. But that shouldn't be that difficult.
Thank you.
Before I turn to Commissioner Summers, just follow up on, if I might, on timing. If we run 45 days, and it does, I should say, for the public and the press, it takes a little while to get things in the Federal Registers. It doesn't happen, overnight. We have Thanksgiving. This might not even be in the Federal Register until after Thanksgiving, if I envision how this works with the folks over at the Federal Register. So this comment period will run well into January. If you take some time to review it, we're probably looking at a proposal in the latter part of February. But I'm personally believe that we have to sort of give guidance on this. If clearinghouses are going to be up and running in the next summer and fall, that we have to finalize all this. So I think the public debate has been helpful, but at some point the five of us are going to have to decide. It may well be that we end up exactly the way it is in the futures world currently, or we might propose something that moves towards the direction of better SEG. But I just think that this is important. It's a good process, but at some point the five of us, with staff's help, are going to have to make a recommendation and a proposal, and I think that's the really critical part to this. I don't know, Ananda, if you wanted to comment.
That's absolutely correct, Mr. Chairman, because I submit the earlier we do that, the better it is, because then everybody knows what the situation is.
And the other thing is, Ananda, while you did express an interesting and helpful perspective there is a difference in the statute by one S.
That is absolutely correct.
And so, as I can assure the public, the General Counsel's office has done research back to the 1930s, and it's been very helpful, and I'm glad we're putting this 85.3 in. I almost want to put the General Counsel's memo on the website. I mean, Dan, you can think about that. But, it's quite a tour de force on legislative history. So, Commissioner Summers.
Thank you, Mr. Chairman. I guess I would start by saying that although I'm not opposing the ANPR, it's not my preferred path. I think that at least one of the options that we've included in this proposal is somewhat unacceptable at this point. I associate myself with Commissioner Dunn's comments on the study and how important I think it would be for the industry or economists to do a study with regard to the feasibility of individual segregation. And I understand that there are questions about it, and they're part of the industry. It's the way that they do business, and that's important for them to protect. But at this point, for us, I just don't know how we move forward with that particular option, yet it's an option in this ANPR. So I look forward to the public's comments. I guess I would suggest that 45 days is probably not enough for the industry to pull together some kind of study that would be timely enough for us to be able to consider before we end up proposing a rule or even finalizing rules in this area. But I'm not sure it precludes us from going down that path in the future. If we find that there are issues that we had not considered with regard to individual segregation, that by proposing the futures style segregation for swaps doesn't preclude us from in the future choosing another path, whether it's for both futures and swaps or for swaps separately. And I guess I would also be remiss if I didn't say that I think Congress would have been a little bit more direct in their statutory language if they expected us to treat these two separately.
Thank you, Commissioner Summers. Commissioner Chilton?
I agree. Some more information would be helpful. So when people tell us about the cost, I'd like not just to know they think it's going to mean X. I'd like to know how they got there. I don't know if they have time to get there, but it's not too helpful to just say, we've already got a lot of that. It's not going to cost much, or it's going to cost a whole bunch. So it doesn't help us much if we just get a number. Do you want to comment on it?
I mean, we ask a lot of very detailed questions to tease out not just simply what is the total cost going to be, but what are the things you're going to need to do differently, how much is that going to cost for you, how is it that one then extends that to the entire industry, and we're asking that really for each of the alternative models compared to the base and looking at it separately in terms of the administrative costs versus the risk costs.
Just one other, which is on the operationally commingled but legally separate system. How would that harmonize or not with international regulatory systems?
I think my understanding is that the European Union is currently working to develop some approaches to this. One of the approaches that has been described to me by some of the European regulators as aspirational is more of an individual customer protection approach. Part of it is, I think, this sort of customer protection needs to follow the bankruptcy codes in each jurisdiction. And so our bankruptcy code provides certain opportunities and certain approaches. The UK is different. France, Germany, they're all different. And so to get a precisely harmonized approach might be difficult unless we can, at the bankruptcy code level, also get harmonization.
Thank you.
Thank you, Commissioner Chilton. Commissioner Malia, and then I'll have a follow-up question after Commissioner Malia because I keep thinking about more things.
You know how hard it is to ask questions when everybody else has gone before you? Because Bart just took one of mine. But part two of my international question was, I understand the LCH has a system similar to the individual SEG. Is that accurate, and does that square with our individual SEG proposal we have, and maybe you could explain any differences or similarities?
LCH has been working on what they call their FCM model, and they have been looking at for essentially for customer swaps. Right now, they're not yet doing customer swaps, I believe. They're rather just clearing on between members. They have been working towards individual customer protection themselves. One of the difficulties in doing that for one clearinghouse would be the way we currently do it in the futures model. Essentially, you don't identify customers by clearinghouse. Rather, essentially, the customers have their claims based on their positions across whatever clearinghouses they're trading with. Whatever money comes back, you look at the total of the claims of each of the customers, and that's divided pro rata without regard to which clearinghouse. And so if we tried to do that, we'd need to come up with a way to say, okay, this is for the LCH customers, this is for the CME customers, and if you're both, then we have to figure out how it is we're going to allocate your collateral between your LCH claim and your CME claim. And so I guess my answer is, it might be difficult to do this in a way that says we're going to treat customers of one clearinghouse different than customers who are trading it at a separate one. Or especially because in many cases the same customers will be at both.
Mr. Chairman, I do appreciate you adding 85.3. This is it. It's single-spaced, 4 or 5 pages. I guess for the benefit of everybody, Dan or Martin, somebody want to take a stab at kind of summarizing what this actually says and why this is relevant to this debate?
If I could add anything you want to do on that wonderful tour de force on the legislative history, but keep it, to that the public can understand it.
85.3 addressed the basic question that Bob mentioned in his statement and we've been talking about. What can a derivatives clearing organization, can a clearing agency use all the funds in the segregated account in the event of an FCM default, not just the customer that may have precipitated the default, but all the customers that were not in default. 85.3 concluded that they could, and it basically said that the property that the statute protects the property of the customers collectively, not singularly, and therefore the individual customers did not have that individual protection. That was basically protected customers collectively, and it relied upon the fact that typically these funds were held collectively rather than singularly, and that had been longstanding industry practice. So it interpreted the statute to support that practice.
I think I would note a couple of things in addition. 85, as I mentioned before, clearinghouses today, and certainly back in 1985, looked at customer collateral on an omnibus basis. And one of the things is that I think back in 1985, both legally and actually, clearinghouses did not know the positions of individual customers. And it would have, I think, given the technology available then, been rather difficult to identify on even a daily basis, this is the property of customer 1, customer 2, customer 3. And so one of the interesting questions is, here we are in 2010 with different technology. Is it practicable for clearinghouses to know customers' positions at an individual level? And I think particularly in the swaps area, it is not only practical, but in fact is happening today. And so that might change some of the underpinnings there. And then, as I think you folks mentioned in the memo, there is that S, which might suggest, and it's difficult because you're right, Commissioner Summers, one would have hoped that Congress, if they're going to speak, would speak a bit more clearly. On the other hand, there is case law that says that if Congress says one thing in one place and a different thing in a different place, we do not assume that they just slipped, but we have to assume they meant different things. And in this case, the S is really what we're all here about. Because essentially it's, do you treat customers as a group or customer individual? And so that missing S bears a special resonance of, gosh, I don't want to take this too far, but it bears a special resonance in connection with the issue that we're discussing here legally. But on the other hand, I think very importantly, in addition to those legal issues, the cost is very important. And I am very hopeful that as the industry looks at each of these alternatives, and I certainly, yes, one of them I think would be very expensive indeed. But I wanted to, it seems to me, get the full spectrum of alternatives. I think some of the other alternatives would cost a lot less. And indeed, one of them I think, but it's up to industry to tell us, would not add to the total industry costs very much at all, but rather would just simply be a risk shift between customers and firms. And then ultimately it would be a policy decision, both in terms of looking at the law and then looking at the policy. Is that risk shift a good way to go?
And
Go ahead.
I would just add to what Bob had said in terms of statutory interpretation. In one of the opinions that we reviewed in terms of another statute where there was a very small difference, Justice O'Connor had noted or had stated, one must presume that the Congress crafts its statutes as carefully as we craft our judicial opinions. So.
And actually, one other thing I should mention. Back immediately after later in 1985, the Commission realized that actually we didn't have an S in our Rule 120B. And the Commission specifically changed it to add the S because they felt that without that S, there was a danger that the clearinghouse would be looked at as having different duties. And so arguably there is Commission precedent that the presence or the absence of a little s does make that kind of a difference.
All right, I think we've done this S thing. I want to move on to moral hazard. You mentioned it that you've asked some questions in your NOPR, or advance notice of proposed rulemaking. Of the 4 proposals that you've outlined in there, which of those offer, at least avoid any moral hazard, therefore the reduction of risk at the FCM level? Clearly, Dodd-Frank was clear about increasing our oversight and managing risk. And I wondered if, of the 4 proposals you have, which of those raise the risk management standards at the FCM level?
I would say that, you can look at this 2 ways. Because I think, arguably, from one perspective, none of them changes our duty, as you mentioned, to look at FCMs who are our registrants. One could argue that to the extent one reduces customer risk, that customers are less likely to apply market discipline by themselves in choosing FCMs. One of the things I try to do is to ask some questions saying, okay, what are the costs of them examining that? I would note also that right now, today, clearinghouses risk manage their member FCMs because essentially it is a requirement under our core principles, and it is in the commercial self-interest of a DCO to risk manage its members because a member default would hurt the DCO. I would suggest, in my personal opinion, that the clearinghouses who are already doing this are structurally much better placed to do risk management. For instance, if a customer goes and asks questions about his fellow customers, he's likely to be told very politely that, there's a limit to how much information we're going to give you because we're only going to tell you about you. Your fellow customers are, among other things, they have privacy interests. When the clearinghouse, which has a supervisory relationship to its members, goes in and asks questions about their risk management and about the risks posed by fellow customers, the clearinghouse has the authority to demand that information. And indeed, the answer they would get is, let me get that information together. The clearinghouses, who are fewer in number, they're in the business of risk management. They have professional, very excellent staffs. And so, essentially, I would argue they are the best place to do this. And to the extent that a number of these alternatives would increase the risks would put the clearinghouse's own money closer to the front of the line, that would only incentivize the clearinghouse to do an even better job than they're already doing in terms of risk management.
I guess the issue is who's going to do the risk management, clearinghouse or the FCM? One of the arguments is
shouldn't they all be doing it?
They should. But if you have the question is there going to be a shift? Because one of the arguments that we heard was if you have individual seg, then the clearinghouse takes on a bigger responsibility to manage the risk of the customer itself, as opposed to leaving it to the FCM. So I don't know whether it's true or not, but one of the arguments was made. I think the firms made that argument that if you have individual seg at the DCO, then you remove the incentive for the FCM to do a good job. And there's some truth to that. So,
Okay. Bob, you mentioned...
as long as Bob keeps his answer a little, sure.
You mentioned the customer relationship to the FCM and their desire to seek better risk management, or ask about that, or what we can ask of them. If we kept the omnibus account structure, how could the FCM swap customer evaluate fellow customers, or at least have a better understanding of where the risk resides at the FCM level? Are there different reporting structures that we could seek, transparency measures we could impose that would improve the overall understanding of how diverse a clearing or a FCM might be, or what risk management procedures they're using? That might give customers greater confidence.
I think it'd be very difficult for a customer to truly evaluate the risk that other customers pose. Because, as Bob pointed out, no FCM is going to disclose information on other customers. So, as with now, the FCM the customer is only left with finding out from the FCM what its risk management practices are. I don't know of a way in which we can make it easier. I mean, short of the FCM saying, well, this is the risk profile, without giving specific information on its other customers, saying this is the risk profile that I have, and this is the risk management techniques that I have. But short of that, I don't see how we can force the.
Could you elaborate on what is being done to improve in this rulemaking to improve the transparency of FCM management, if anything?
We're not doing this rulemaking. The advance notice is not.
I did say I'd have a question. And I'm going to ask Anand, just because his crispness is just. In the futures world, what does somebody do? A pension fund, asset manager, maybe a hedge fund do if they're concerned about this fellow's customer risk, and does that sometimes include becoming a clearing member themselves directly?
That's certainly possible. That's one option. The challenge there would be to, one, assemble a infrastructure to be able to clear.
But do some large hedge funds or asset managers self-clear? I mean, in the futures world.
No. They may describe themselves as clearing.
As a clearing member?
As a clearing
not
member.
A clearing member?
No, I think I may be wrong, but I think there are some hedge funds which are clearing members of the Chicago Mercantile Exchange. I'm not sure that they directly clear. They may go through somebody else to directly clear. I'm not sure. I need to check on that.
Okay.
There may be one or two, but that is certainly one option.
Because it just strikes me, and then I'll be done, it strikes me another important component of this are the rules that we'll take up in mid-December on the risk management of clearinghouses, which will include rules, John Lawton I see there who will be help writing them, on participant eligibility.
Right.
And it strikes me in the futures world it's very inclusive. All 120 or so futures commission merchants can participate, and I think that gives then the buy side more opportunity to sort of, they can pick amongst 120 or so futures commission merchants. The swaps world today has been more concentrated, fewer members. So I think there's a related issue here when we take up that proposed rule.
Well, Mr. Chairman, not all FCMs are clearing members. This is a subtotal, but you're right. There are, 60, 70 clearing FCMs. So customers have an opportunity to decide where they want to go. The other thing is, the Commission publishes monthly the report on the capital of FCMs, both the requirement and how much they have and how much funds they have under segregation. So people have an opportunity to look at that report as well.
Part of the reason I raised it, I'm trying to speak through this meeting to those who really want individual segregation. There's other ways that they might be able to seek those protections, and I think we have to think through that participant eligibility, because maybe that's a way to get more competition and broaden the participation of the clearinghouses on the swap side. I think the future side has benefited from that. But
let me just, you did raise we do publish monthly a table in which,
Yes.
but you can't, it doesn't make any sense. It doesn't give, I think, customers the granularity they're looking for in terms of where risk management resides. You and I have talked a little bit about it, but it's a difficult table.
so
to
another
understand.
thing on the to-do list, Ananda.
Yeah, it's the issue is how much information you can disclose.
Yeah.
The thing is,
Why don't we just say another thing on the
another
to-do
thing on the
list?
agenda, yeah.
Okay. Not hearing any further questions, I thought I'd call the vote. All those in favor, please say aye.
Aye.
All those opposed say no. The ayes appears to have it. The ayes have it. Thank you very much for both of these. I think next we're going to have, is Jeff going to come up on this must be swap data repository. Susan, you're going to come up too, I hope. Jeff Burns and Susan Nathan. Susan is in the Division of Market Oversight. Jeff Burns is in the Office of General Counsel. Have been, I'm allowed to say, co-leading this, and they'll be presenting rules on swap data repositories. Jeff, you've got a colleague from the Office of General Counsel.
Another colleague of mine, this is Bill Banwell from the Office of the General Counsel. He's been my deputy team lead throughout the rulemaking.
All right. So, Susan, Jeff, Bill, the floor is yours, and go ahead.
Okay, thank you. Thank you, Mr. Chairman, Commissioners. Before I begin, I'd like to thank my deputy team lead, Bill Banwell, as well as Susan Nathan, and the rest of the team members who were tireless in their efforts to get the rulemaking done for today. Today's staff is recommending that the Commission approve a notice of proposed rulemaking to implement new regulations set forth in proposed Part 49 of the Commission's regulations regarding the registration and regulation of swap data repositories, or SDRs for short. SDRs are entities that collect and maintain swap data. The core function of an SDR is to ensure the storage of accurate data in order to facilitate transparency and reporting in the swaps market. The staff, in connection with the proposal, has consulted and coordinated with staff from various agencies such as the SEC, the Fed, the Federal Reserve Bank of New York, the Office of the Comptroller of the Currency, the FDIC, Department of Treasury, the European Commission, and the Committee of European Securities Regulators. We have attempted to incorporate input from all parties to the extent possible within our statutory framework. Proposed Part 49 is consistent with various international standards that have been published for trade repositories. In particular, we have sought to conform our regulations with guidelines identified in a CPSS IOSCO consultative report entitled Considerations for Trade Repositories in the OTC Derivatives Markets. We believe proposed 49 is consistent with the goals of this report. We would also note that Part 49 is consistent with the European Commission's recent proposal related to trade repositories. To enhance transparency, promote standardization, and reduce systemic risk, Section 728 of the Dodd-Frank Wall Street Reform and Consumer Protection Act establishes SDRs to collect and maintain data and information relating to swap transactions and to make such data and information available to a variety of regulators. All swap data, whether cleared or uncleared, will now be reported to an SDR. The proposal sets forth, or our proposal specifies a number of requirements. First is the registration requirement and the adoption of new Form SDR. The second, I'll call it bucket, is the statutory duties set forth in new Section 21C of the Commodity Exchange Act, as well as the core principles applicable to SDRs outlined in Section 21F of the Commodity Exchange Act. Additional duties are also permitted by Section 21F4 of the Commodity Exchange Act, as well as we also provide, which is provided in Dodd-Frank, the designation of a chief compliance officer, as well as, lastly, real-time public reporting obligations. I will briefly describe each of these requirements. First is registration. Applicants are required under the proposal to file electronically the registration on new form SDR, which consists of instructions, general questions, and a list of exhibits necessary for determination by the Commission of whether an applicant is able to demonstrate compliance with the core principles, statutory duties, as well as other requirements in proposed Part 49. There will be a 180-day review period that may be extended by the Commission for good cause. Upon request by an applicant, the Commission may grant a provisional registration to an SDR applicant as an interim implementation provision. The Part 49 rules also prescribe procedures for revocation of an SDR registration and for the registration of successor entities. A particular note, I think, also is those SDRs located outside of the United States. For those SDRs, they'll be required to certify on Form SDR and provide an opinion of counsel that the SDR is able, as a matter of law, to provide the Commission with prompt access to its books and records and can submit to an on-site inspection and examination by the Commission. Turning next to the statutory duties required of an SDR. These are minimum duties in order to become registered and to maintain registration. They include, and these are all listed or set forth in Dodd-Frank itself, and we're just providing a little more flavor and implementing them into the proposed Part 49. First is the acceptance of data. As a result of this statutory duty, if an SDR accepts the swap data of a particular asset class, it will be required to accept the data for all swaps of that asset class. So in other words, you couldn't pick and choose your swaps that you're going to accept. As part of this requirement as well, an SDR will not be permitted to alter, modify, or otherwise amend an fully executed swap agreement. The second duty is confirmation with both counterparties to a swap of the accuracy of the data. This requires a registered SDR to establish policies and procedures to ensure the accuracy of the data and other regulatory information required to be reported. We envision compliance with this requirement through either electronic matching or confirmation services or by actual direct communication with counterparties. Going on to record keeping, the SDR is required to keep books and records for the life of the swap plus 5 years in a readily accessible manner. Thereafter, the swap data is then to be archived. We haven't determined the length of time yet regarding the archive data, but we put it out for comment on how long that should be. Also, an SDR that accepts and disseminates swap data for real-time reporting purposes would also need to meet the real-time public reporting record-keeping requirements that are going to be proposed under Part 43. The next duty, which I think is one of the most essential ones, is providing Commission direct access to the data maintained by the SDR. This will consist of real-time access via web-based protocols, as well as an information push-out to the Commission at specified intervals. Next also is that the SDR also is required to establish automated systems for the monitoring, screening, and analyzing of swap data. This would include the end user exception as well. And as part of this regulation, the SDR is required to maintain sufficient IT staff, other staff, and resources so that it is able to fill these requirements. The sixth, I'll call it statutory duty, is the maintenance of privacy or confidentiality of the swap data that the SDR receives. Each SDR will be required to adopt policies and procedures that would keep the data private, since the SDR is just holding the data, and they have to be reasonably adopted to protect the confidentiality of all data, except for that data that is subject to real-time reporting. The way I think we envision this working is there are two pipes. It's the real-time pipe as well as the statutory reporting pipe, since obviously the real-time reporting could not be subject to privacy and confidentiality. Another, I think, very, very important regulation is the SDR access for other regulators, both domestically as well as foreign regulators. The requirement is really, it tracks Dodd-Frank, but one of the things that is required of the SDR is upon request, they would have to notify the Commission of the access. But before they could provide access, they would have to have an executed confidentiality and indemnification agreement with the SDR for any litigation expenses that might occur due to the accessing of the data. And lastly, in terms of statutory duties, concerns emergency procedures. The SDR would have to have procedures so that we would have contact information or the actual staff contacts at the SDR, as well as the standards for declaring an emergency. And all these statutory duties are set forth in proposed regulations 49.9 through 49.18. Turning next to the core principles, there are three core principles. First is the antitrust considerations. Our proposed regulation 49.19 implements core principle 1 related to antitrust, and it requires the SDR to avoid rules that provide an unreasonable restraint of trade or imposing any material anti-competitive burden. Next is governance arrangements. Proposed regulation 49.20 provides for transparent governance arrangements to fulfill public interest requirements and to support the objectives of the federal government, owners, and participants. The governance rules also impose certain minimum standards for the transparency of SDR governance arrangements, and these include a statement in the charter regarding transparency of the governance arrangements, making certain information available to the public, such as the mission statement, charter, nomination process, ensuring available information is accurate, and disclosing summaries of significant governance decisions. Governance rules also require policies and procedures.
I'm just wondering, I keep seeing lots of pages.
No, not too much, actually.
All right, thanks.
No, two more, actually. But they're big. I'll speed it up. The governance rules require policies and procedures to ensure that the board adequately considers perspectives independent of competitive, commercial, or industry interests in its deliberations, and also set forth expertise requirements, removal procedures, and rules and responsibility guidelines for directors. Moving to conflicts of interest, proposed Regulation 49.21 requires SDRs to establish and enforce rules to minimize conflicts of interest in its decision-making process and to establish a process for resolving these conflicts. These include, but are not limited to, discrimination against certain reporting entities or unfair or anti-competitive disclosure by a control group. Core Principle 4, which provides the Commission with the authority to provide or adopt additional duties. We've listed 4 additional duties. The first one is to have disaster recovery and business continuity plans. The second is for the SDR to maintain sufficient financial resources. The third is the provision to provide a disclosure document setting forth the risks and costs associated with using the services of the SDR. And lastly, the SDR would be required to provide fair and open access and fees that are equitable and non-discriminatory. The proposal, as Mr. Chairman indicated, will be out for 60 days. During that time, we're requesting comment specifically on whether there should be an implementation or phase-in period under the proposal. And that ends my remarks, and I'm happy to take any questions.
Thank you, Jeff and the team. Do I hear a motion on the staff recommendation on swap data repository proposed rules?
So moved.
Second.
I support the proposed rulemaking. I think the proposal does implement Congress's mandate that the swaps data repositories be regulated and that we write rules for them. I think it importantly includes provisions for the maintaining of that data, but also that we as regulators get direct access to that data, which is so critical. It is also has provisions such that in another set of the statute, it talks about commercial end users being exempted from the clearing requirement, and there's a notice provision there, and I believe the rule includes that this swap data repositories, as Congress had provided,
It does.
Could receive those notices, and that these swap data repositories will play a role in the real-time reporting as well as in collecting data and maintaining data over the whole life cycle of the swap. I think this is all critical to enhancing transparency. I do have a couple of questions, and it sort of relates to the relationship between this rule and the real-time rule, but I just want to make sure that I understand how they relate to each other. And I might be asking for a question to be added because I'm just a little confused about one thing. In the real-time reporting rule, which we're yet to discuss, there's some provision that swap data repositories will facilitate real-time reporting, and I think you have that here as well. Is that correct, Jeff?
We do. We have included it in the proposal.
But what I'm less certain about is third-party data providers, that if I think the real-time reporting requirement also provides that maybe there would be third-party data aggregators as well. Is that right?
That's my understanding.
Yeah. So my question is under the statute, under 728 of the statute, might it not be that those third-party data providers should also register as swap data repositories? If so, shouldn't we at least in this rule, ask that question of the public so that if we think that they should also register as swap data repositories?
I think that's a very good question to put in the proposal and ask for public comment.
Mr. Chairman?
Sure, please.
Who are these third-party aggregators that
Well,
we're talking about?
I think they're market data vendors, primarily.
Like Bloomberg or?
Like a Bloomberg.
So we're going to make Bloomberg register as a SEP?
No,
The question is?
no.
As an SDR.
As an SDR policy.
The question is,
That's the question.
It's a statute. I don't know if I don't think it does require it right now as it's written.
Yeah, as it's written right now, it does not require that.
But I had the question of asking the public, should they have to be required to register as a SDR?
I just want to make sure we're talking about the same people.
I think it would be a data aggregator like the company you mentioned, who might. It's basically the intersection. Swap data repositories are going to be having regulatory data, a lot of data that's important to regulators, and then they have this streaming real-time data.
It's kind of the two pipes, I would say.
And what if somebody's only in the second pipe? If they're only in the real-time pipe, don't they have to register as a swap data repository, or at least shouldn't we at least ask the public that question so that our final rule could address that?
I think it makes a lot of sense to put it into the proposal and ask the question.
So maybe I'll ask unanimous consent to include such a question. Not hearing any objection. No objection. Okay. That was my main question. Commissioner Dunn.
Thank you, Mr. Chairman. I have a great deal of concern about the resources we have to implement this, both the human and technical. And 180 days for us to review the request. Do we have sufficient staff? Well, first of all, how many do we anticipate receiving, and do we have a sufficient staff to do that review within that 180-day time period?
Well, I think we believe we'll have 15 or so maybe applicants.
Before the ones that the chairman just added.
Well, the world could get a lot larger, but that's what we were expecting, somewhere around 15 or so in terms of.
Yes, in terms of staffing, we have not, got staff at the moment to do this, but as part of the request for the budget request to implement Dodd-Frank, we've estimated that, with respect to the initial number of SDRs and then the ongoing oversight, that it would take about maybe 5 to 10 people, depending on what the final rules look like and the overall scope of our oversight. But that's something that is built into the budget request so that we could accomplish that.
I would imagine that we will probably receive requests for more repositories in a single asset class than one in some occasions, and we're requesting them to do a certain amount of analysis and overview of what they have in there. Where we have repositories that have more than one asset class, then is it going to fall back on the commission to be able to get that information and do the types of an analysis that we've got, and do we have the technical ability to do that at this time?
John Rogers, when we do the next rulemaking for the actual the SDR data requirements, I think he might be able to address that. But I think ultimately now it's something that we in this division, as well as our IT folks, are looking at, and it's not that we have the capability at the moment, but again, it would be something that would be part of the budget request to upgrade our IT resources and staff to carry out these duties, to be able to get the data and analyze it and incorporate it into our other responsibilities looking at the exchange-traded markets.
Thank you, Mr. Chairman.
Commissioner Dunn raises a very good point. I think the President's budget for 2011 included $45 million for implementation, of which $18 million was for technology. When we look at 2012, we think that even grows. But that $18 million for technology is very important to be able to basically have the pipes. We need direct feeds into these swap data repositories. We need to be able to do all the things Commissioner Malia has been suggesting, and good things out of his tech advisory committee and so forth. So, Commissioner Summers.
Thank you, Mr. Chairman. I have a number of different concerns and questions with this release, and I'll start with the provisional registration, which I raised questions on a previous release on this exact same issue. if you could walk through for me what benefit there is in us provisionally registering these SDRs that are already up and running right now without having gone through the due diligence of actually registering them as an SDR. So if somebody could walk me through that.
I believe this really has to deal with, as Rick had mentioned, staffing issues going for initially, because there is a sunset provision on the provisional application, a 1-year period. But I think initially if we get 15, maybe more applicants in terms of the staff able to review and then approve the applicants in time, this would give us the ability to provisionally approve an applicant who is already operating as a trade repository and who we believe is in substantial compliance, but we haven't had the time to go ahead and do a full review.
So are we required by the statute to have these people registered? So that's why we're doing this provisionally. And how do we decide if they're substantially compliant if we haven't even looked at them?
Well, I mean, in terms of timing, we wouldn't be able to have an entity to accept any of the swap data unless an SDR is registered. So we would have this vast data that hasn't been reported anywhere.
But these people are already reporting to these places, right?
There are interest rates, CDS, credit.
I guess what I'm trying to get at is what we envision as entities that would be eligible for provisional registration are these same entities that are already up and running and already accepting all of this data, right?
Rick, what do you think?
I would think presumably that would be true, but it could possibly be in an existing clearinghouse or someone that has some capability to perform these duties. But I think the goal is to try to get something up and running, and if we don't have the ability to immediately review and process all these applications, it's a way to not create more legal uncertainty for the industry to get something up and going, but then still come back and do the full due diligence review. And presumably we'd set out some criteria. We're looking at
Criteria for substantial compliance, because I guess that's also where I have questions. How do we decide what substantially compliant is, and is it only for those people who are already acting as these data repositories? What if we have other people who believe they could be substantially compliant asking
that may be
for
something,
this?
if the commission decides to go through with that in a final, that may be something we have to provide more guidance on.
And also the provisional would give the commission the ability to access the data.
Another line of questioning for me relates to foreign SDRs and how we decide. I think that there's a couple of concerns that you outlined when you were giving your summary with regard to the indemnity and foreign regulators having access to information at a U.S. registered SDR. But what about foreign SDRs? And I think one of the provisions in the Act, if I have, says specifically that it excludes from U.S. jurisdiction all swap activity that does not have a direct and significant connection with activities in or effect on commerce of the United States. How do we decide what kind of swap activity has a direct or significant connection? So is it if one of the counterparties is, are we defining that?
I know this has not been defined yet in any capacity. It's a pretty broad definition and could have various permutations. But we have not defined it, nor do I believe any other rulemaking team, at least to date, has.
And
I guess though if a foreign SDR is engaging in U.S. activity in terms of coming here to the U.S., that would obviously have an effect on U.S. commerce.
With regard to the foreign SDRs, and we have a part in here that explains how we would contemplate registering foreign SDRs. If you could walk me through that and kind of what concerns we have, why isn't just an information sharing agreement sufficient?
Could I just add something first? I think that the goal, and I don't know how this will end up, is to not have foreign SDRs, U.S. SDRs. I mean, there may be SDRs that will come in seeking registration, as some are that are located overseas. But I think in working with these international regulators and IOSCO and all this, to have that may end up with single or multiple SDRs per asset class, but that'll be where all the regulators will have access to that information and they'll comply with generally accepted. I mean, they may be registered here, but they may be meeting requirements overseas. So I think the goal is to, and again, I don't know how this will work out, but it's so that where you have the foreign versus the domestic isn't what we're striving for.
I couldn't agree more, but that's not what this release sort of contemplates or lays out. So it's a little bit confusing in how this may
I think part of it has to do with Dodd-Frank, in that it doesn't give us the ability to exempt. So that if you're a foreign SDR, we have to register you. Now, maybe that could be done in a lighter way, but the way this would work is they would have to file the Form SDR and provide that opinion of counsel that would allow us to get books and records, as well as on-site inspections, so that we are able to do our regulatory duties because of the fact that we don't have any exemptive relief for it.
I think I'll stop there. I have a number of other questions.
Thank you, Commissioner Summers. But please don't stop there in our bilateral and our individual discussions, because we benefit from these comments. And I think the foreign and domestic issues here, we have to find a way, working with international regulators, that we all have access, and it doesn't matter where they're located.
And I believe that's the goal. I mean, these are difficult issues in the conform of Dodd-Frank.
Commissioner Chilton?
I was interested in Commissioner Summers' questions. I was trying to look at the Act, not Dodd-Frank, but the CEA. And so, you got to read them together. And in Section 3, 1031.3, the finding, it says, the transactions subject to this Act, CEA, are entered into regularly in interstate commerce and international commerce, and are affected with a national public interest by providing a means for managing and assuming price risk, discovering prices, and disseminating pricing information through trading in liquid, fair, and financially secure trading facilities. Does that definition add to the conversation you're having with Commissioner Summers?
I think it's consistent with what Commissioner Summers was indicating.
Okay. Mr. Burns, are SDRs established under Dodd-Frank? Are they intended to be sort of public utilities like PUCA with the SEC for the aggregation of swaps data?
Although SDRs provide what I'll call vital regulatory function, I don't think that is the intention, to make them a public utility. The statute doesn't provide that, and I wouldn't assume that these are public utilities, although they may have some aspects of a public utility, in the sense that the data will be maintained in one place for regulators, both domestically and foreign, to have access to. But I would resist any indication that these are a public utility. I don't think the statute calls for it.
Thank you. And to sort of follow up on the international question, do other regulators, in Europe and the UK, do they require that there's a single data repository, or are they intending on doing that?
Currently, we know of no legislation in Europe that would require that. That may happen, I think, just over time with the market.
By the market.
But not from a regulatory mandate.
Okay. We talked earlier, and I know that it sounded like we were probably dancing on the head of a pin, but words are important, and even letters are important. So just like Sesame Street had, like a letter of the day. So my question is brought to you also by the letter S. If you look at Section 728, and if you go through it, there are multiple references to swaps data repositories. It's actually an IE and an S. So it's not swap data repository. And I count at least 11, and I won't go through them all, but there's 11. And a couple, it's not all S. Some of them say each swap data repository. And then it says swaps data repositories, and then it says each. And anyway, so my question is, given that these things do mean things in law, does that indicate some requirement for plurality of SDRs?
That would seem to be the case, but I also think it was the presumption of Congress that there would be multiple SDRs.
Okay. And final question, ICE sent a letter, and they talked about how, I thought sort of a natural place for SDRs would be at the existing clearinghouses. Is there anything that would prohibit that from taking place in what we're considering?
No, in fact, the statute presumes that clearinghouses would register as SDRs.
Okay. Thank you.
Thank you, Commissioner Chilton. Commissioner Amaya.
I have one question. In all of the data and how we move it and send it from a SEF and real-time report it and then send it to an SDR, who owns the data? And does it change through the process?
Well, the SDR...
Can I just add, because and do we do anything to change, is it in this rule?
Mm-hmm.
Because his question, I just want to add to Commissioner Amaya, do we do anything to affect that?
We don't believe that the SDR owns the data. The data is the property of the counterparties, who then report it to the SDR. The SDR is a warehouse that maintains the data, and from that they then don't manufacture property rights in the data just from maintaining it. Now they will have a license to use the data through their user agreements that they'll have with counterparties, but the data is the counterparties. And we don't change that in the proposal at all.
I think it's an excellent question. You said the counterparties, but if it's done on a matching engine, might it not be the matching engine or what we call a CEF's data? Or is that, again, we don't change that. But
we don't change that, and I would hate to get into a property rights discussion.
No, and I'm not a lawyer, nor am I property rights. But I was most interested that if we're neutral on it.
We are neutral. We don't say in the regulation at all, and or the preamble, who the owners of the data are.
If there are no further questions, the motion in front of us, as amended with the unanimous consent, is on the proposed swap data repository rules. If I could hear by voice the ayes. All in favor?
Aye.
Aye.
Any opposed?
No.
The ayes appear to have it. The ayes have it, and so we thank you, Swap Data Repository Rulemaking Team, and I think we're now on to, I can't see David here, he's in the back, but the data elements and like, I'm conscious that we're moving along here, and if commissioners want me to break at any time, I'm glad to, but thank you all. Well, we have all four of you. So David Taylor, who is from the Division of Market Oversight and has been ably heading up a team on data, and this is data for swap dealers, data for major swap participants, data for clearinghouses, swap execution facilities, designated contract markets, possibly even for futures commission merchants and others, not only how they maintain the data, but also what they have to send to a swap data repository. I would just say this for the public's benefit. We chose earlier, since there are so many data requirements on each of these registrants, that the best way to provide consistency, which the statute says there should be consistency, is that we asked one team to do data elements for all of the different registrants. So this actually has an effect on all of them. But Irina Leonova, who's been, I would say, maybe David's deputy, seems to be in all of the meetings in these very important matters. Ann Schubert, who is on the team, are also from the Division of Market Oversight. And then John Rogers, who here at the Commission is our Chief Information Officer and deals with all that we do in terms of information. And we felt it was critical to really have this coordinated, not just from market oversight, but our own data elements and requirements. So with that, David.
Good morning, Mr. Chairman and Commissioners. My script said good morning, and I took a look, and I can still say it. I do want to thank, before I begin, my fellow team members, in particular my multi-talented and indispensable deputy team lead, Irina Leonova, for their hard work in preparing the proposal I'm about to present. Today, staff is recommending that the Commission approve a notice of proposed rulemaking to implement new regulations regarding swap data record keeping and reporting. These regulations would govern the reporting of swap data to swap data repositories, or as I'll say later, SDRs. The fundamental goal of the regulations is to ensure that complete data concerning all swaps subject to the Commission's jurisdiction is maintained in SDRs, where it would not be disclosed publicly, but would be available to the Commission and other financial regulators for fulfillment of their various regulatory mandates. In preparing these regulations, staff has engaged in extensive consultations with other U.S. financial regulators and with international financial regulators and organizations, and has reviewed and considered the work that has already been done internationally with regard to derivatives reporting. The regulations are designed to take into account the differences between various swap asset classes with respect to product types and associated data, as well as their market structures and trading processes. The regulations are also designed to minimize, to the extent possible, the regulatory burden on the industry, especially for end users and other swap counterparties who are not swap dealers or major swap participants. The swap record-keeping provisions we are proposing are based on the Commission's existing record-keeping regulations. They generally call for registered entities and counterparties to keep records relating to swaps throughout the existence of the swap and for 5 years following final termination or expiration of the swap. The records would need to be readily accessible through the life of the swap and for 2 years thereafter, and retrievable from storage within 3 business days during the remainder of the retention period. In order to ensure that complete data concerning swaps is maintained in SDRs and available to the Commission and other regulators, the swap data reporting rule calls for reporting of swap data from each of two important stages of the existence of a swap: the creation of the swap and the continuation of the swap over its existence until its final termination or expiration. For both creation and continuation data involving credit swaps and equity swaps, where we will share jurisdiction with the SEC, the rule is aligned with the approach taken in the SEC data rules in order to avoid the regulatory burden and regulatory arbitrage that could come from having two dissimilar reporting regimes. To ensure timeliness, accuracy, and completeness with respect to data, the proposal requires reporting of two types of data relating to the creation of a swap: the primary economic terms of the swap, verified or matched by the counterparties at or shortly after the time of execution, and then all of the terms of the swap included in the legal confirmation. To ensure inclusion of primary economic terms necessary for regulatory purposes, the rule specifies minimum data elements or data categories that must be reported for swaps in each asset class, and seeks comment on whether additional data elements should be required to be reported. Continuation data reporting for credit and equity swaps follows the life cycle approach and requires reporting of all life cycle events affecting the terms of a swap. Reporting of continuation data for interest rate, currency, and other commodity swaps follows the state or snapshot approach and requires reporting of a daily snapshot of all the primary economic terms of a swap, including any changes that have occurred. And for all asset classes, continuation data reporting also includes specified valuation data. The proposed rule calls for reporting by the registered entity or counterparty that has the easiest, fastest, and cheapest access to the data in question. Such entities and counterparties are also the most likely to have automated systems that are suitable for reporting. Counterparty reporting would follow the hierarchy outlined in the statute in parallel with the SEC reporting rule, giving dealers and major swap participants the duty to report when possible, and limiting reporting by non-swap dealer and major swap participant counterparties, including end users, to situations where there is no dealer or MSP counterparty. The rule also explicitly permits third-party facilitation of data reporting without removing the responsibility involved from the appropriate registered entity or counterparty. The proposed rule also calls for the use of three unique identifiers in connection with swap reporting: a unique swap identifier, a unique counterparty identifier, and a unique product identifier. These unique identifiers will be crucial regulatory tools for linking data together and enabling data aggregation by regulators across counterparties, asset classes, and transactions. This will enhance regulators' ability to mitigate systemic risk, prevent market manipulation, conduct effective market and trade practice surveillance, enforce position limits, and exercise resolution authority. Such identifiers will also have great benefits for internal record keeping and risk management by financial entities themselves. Staff has consulted with the SEC concerning the use of these unique identifiers. The USI, the swap identifier, would be created at the time a swap is executed, shared by all registered entities and counterparties involved with the swap, and used to track that particular swap over its entire existence. The UCI, or counterparty identifier, would identify the legal entity that is a counterparty to a swap. The rules provide that the Commission will require use of UCIs in all swap data reporting, selecting an internationally developed identification system for this purpose if one meeting the Commission's requirements is available prior to the implementation date for the rule, or imposing a system created by the Commission if that is needed. Confidential data concerning the corporate affiliations of the legal entity involved would allow regulators to monitor swap exposures. The product identifier would categorize swaps with respect to the underlying products referenced in them. This will allow regulators to aggregate, analyze, and report swap transactions by product type, and will also enhance position limit enforcement. To avoid fragmentation of data for a given swap across multiple SDRs, the rules require that all data for a particular swap must be reported to the same SDR. And finally, regarding data standards, the computer language used in swap data reporting, the proposed regulation requires SDRs to maintain data and transmit it to the Commission in the format required by the Commission. It permits an SDR to allow those reporting data to it to use any data standard acceptable to the SDR, so long as the SDR remains able to provide data to the Commission in the Commission's required format. The proposed regulation will be open to a 60-day public comment period. That concludes my remarks. We're happy to answer any questions.
Do I hear a motion on the staff recommendation on data?
So moved.
Second.
Thank you, David, and everybody on the team. I know you've coordinated not only in this building, because you have to coordinate with 29 other rule teams, because this is data for all of them, but with the SEC and the Federal Reserve, bank regulators, the Treasury's standing up the Office of Financial Research, international regulators. I know you've gotten comments on your term sheets and your draft rule from all of them, so I don't really know how you do it. But I thank you. This may be one of those areas that it has had the broadest consultation. I do support the proposed rulemaking. As I said earlier, it covers the data for all of the different registrants, whether it's a swap dealer, trading platforms, clearing houses, that which needs to be maintained and sent over to the swap data repository in some circumstances. And I think it's important that that be consistent. And so however the public comments on it, I think it's really important that, and the statute says that these are consistent across, that we don't have even regulatory arbitrage on data elements. I think it's also the proposal, and why I'm supporting it, and as I've learned more about data, is that a swap exists over sometimes a period of days or many, many years. And so what the rule includes is that there's data at the day of the transaction or even the moment of the transaction, but it has this continuing data or life cycle data over the course of the life of the swap, and I think that was very important. And I think that the third element, and why I support it, and I compliment the team, because I must admit before July 21st I had not been familiar with this whole concept in terms of unique identifiers. It was the team that identified it, the industry, market participants. Many people have come in the meetings and said, this would be a big help if some regulatory body or swap data repositories or somebody had unique identifiers. And many people in industry, in the financial industry, this is, usually not end users, but in the financial industry, have said they too would benefit if there was a unique identifier for their counterparties. The Europeans and the U.S. regulators also seem to chime in, and you've included, I think, a thoughtful proposal on that regard. I think the 60-day public comment period is warranted, but I also think if the Administrative Procedures Act allows it, hopefully General Counsel Berkovich is poking up now, but that we could possibly, even as we go forward on this, have roundtables. You know, we get the 60 days of public comment, and I think it would be appropriate if it's allowed under the Administrative Procedures Act to have roundtables then, because we'll have these thousands of comments, and then staff will be trying to help do a recommendation, whether it's finalizing the unique ID, which is a really important component, or any other component. So I guess my first question is that allowed under the Administrative Procedures Act to do, you know, the roundtables post those 60-day comment period?
And my general impression on that is yes, Mr. Chairman. I'll defer to the General Counsel to be sure.
Yes. You want to? So,
yes, we could. The Commission could do that.
I think General Counsel Berkovich said yes. So I think that would be very helpful, because these are really important concepts. We want to get them as close to right as we possibly can, and I think you've put together a strong proposal. But with that, I'm going to. I thank you. I'm going to keep you to that we can do that. Commissioner Dunn.
Thank you, Mr. Chairman. Again, my concerns is our wherewithal to fulfill this, especially in the IT area. And perhaps Mr. Rogers could amplify on where we are in that?
Certainly. Excuse me. Well, as Chairman Gensler had mentioned before, we have put in a budget request of $18 million in the 2011 budget, and then an additional amount in the 2012 budget to support the implementation of these particular rules. In preparation for that, in advance of that, we've been, for the last 2 years, refreshing our technology infrastructure so that we have the network bandwidth, the storage capacity, and things like that to accommodate the receipt of additional information. We'll need to make an additional investment, obviously, as mentioned, to first and foremost, I guess, understand the business requirements that we have within the Commission to build up surveillance capabilities, tie those to the existing capabilities that we have as we oversee the futures market, and continue to enhance the infrastructure to support that. So, in essence, we have an additional request that we need to make, but we've established an infrastructure foundation that we think allows us to make that investment moving forward.
The idea of developing USI and UPIs, I think, deserves a great deal of merit, but I'm also understand there are a lot of other players out there that have ideas of how that could be developed, especially on the international scene, whether it's going to be an ISO type of a piece that's put together. How are we doing outreach to all of those other players out there, and at the end of the day, making sure that we've got something that is in fact truly universal?
That's our intention, Commissioner Dunn. We've already done all the consultation we could do and still sleep, and we're going to keep doing that.
You still have time to sleep?
A little. We're participating in the Commission's participation on the IOSCO task force, and that helps us to do this consultation. Our intention in drafting the rule was to allow for an international consensus to develop on especially the counterparty identifier. We've laid out principles we think would get us there, and we hope that this provides an impetus for the world to come together on a solution.
I know in some of the entities that I have visited, they have already built in their own identifiers. What happens to those, and how will those mesh with what we're proposing?
The rule explicitly says it's perfectly all right to have your own identifiers. John can tell you, I think pretty much any system will create an identifier for something that it handles. We just want to add one that will be universal.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. I want to thank this team. This is, really complicated stuff, and I think that you've done a great job putting this all together. I have questions with regard to specific language that we're using and how this overlaps with the real-time reporting. So in the statute, the language technologically practicable is used, but in other places and in this rulemaking we use promptly. So is there a difference between those two, and is there meant to be a difference?
I think the answer is yes, there is, because I think we use the word promptly when we're dealing with end users, non-dealer, non-MSP counterparties. We try to take great care not to lay more burden on them than was required. We have basically asked for comment every time we're asking them to do something on what the appropriate burden should be.
And when we have been consulting with the SEC on these rulemakings, do you know if the time frames that are included in our proposal today, if they're identical to what the SEC is doing?
Yes, we did consult closely about that, and they are, with one exception, for situations where there's reporting where no technology is involved, something not executed on a platform and not affirmed or matched electronically, we're asking for comment on the length of the time there. I think they're saying 24 hours. We're not opposed to that, but we just wanted more input.
Okay. Thank you very much.
Thank you, and thank you for taking great care that when it's an end user to an end user and there's no swap dealer, I think it's a very small part of the market, but I thank you for taking care in that regard and the use of the word prompt rather than some other words. Commissioner Chilton.
I just had a quick comment. I support the rule. You all have done a good job. The proposal. It's a big, long letter from some of the not-for-profit energy end users that they said was on the data record keeping and reporting task. You don't have to scurry too much, Irene. I'm not going to ask a question on it, but it's 47 pages long, so you'd be rushing to find the part anyway. But it makes this has this concern, which is a concern that a bunch of us have raised. Commissioner Summers raised it a bunch about how do you do these things without definitions. They are also special and don't want to be included here, and if they're not special enough to be excluded, they want a transition time, but essentially they're saying, well, we don't even know because we haven't done the definitions. And but sort of like I said earlier, I mean, this is becoming clearer and clearer as we go forward. And I understand it's a little tenuous now, but I think ultimately this is going to be very good. We're going to let people know they're getting a visual where we are. It's going to be increased transparency, and it's going to be good for consumers, including the not-for-profit energy users. So thank you.
I know that the public would as much want to know as the commissioners. The entity I said I was going to hold on this, but I guess I just got to try to rip this Band-Aid. But the entity definition rule we're calendaring for our next meeting. I think that's December 1st. Cyrus here keeps saying, yep. So, but I mean, it's this commission, it's another commission, it's everybody's edits. You all do have a draft, but I know there's commissioners there, wonderful individuals. I know them each. They have it, so it's trying to get this all aligned in everybody's edits and comments. And our next meeting is December 1st, and the entity definition one is, that's what we're trying to do. But I'll try to speak about the overall calendar at the end. But
you talked about, we've all talked about balance. I think Commissioner Summers balancing the international. I think Commissioner Dunn mentioned it as well, and you mentioned you were going to lead the world. Proposed Reg 45.4B3 provides that the identification system must be made by a voluntary consensus standards body and an associated registration authority on a nonprofit basis. Do we have a sense of whether that's going to be here or abroad? And when we lead the world, the voluntary consensus part, leading the world, that doesn't seem, how are we developing consensus without dictating?
Well, our intention is not to dictate. That's why we set out principles that we thought the Commission would want followed for this identifier. But the way it's going to work best is if the world does come together and agree on a standard for these legal entity identifiers. We think it's possible through an international voluntary consensus body that can be done. We were advised by the people we consulted with that it's sitting there almost ready to go. It isn't so much that we want to lead the world. We just want to finally actually provide the impetus that everybody can kick the ball into the net. Everybody wants this. They've been working on it for 10 years, but it needs a push. Dodd-Frank makes the push.
Do you believe that this, you said it's on the doorstep, is that push, is that going to come in consistent with our rulemaking timetables?
I think the push is really our rulemaking, our calling for these identifiers. But yes, our understanding is that it is possible, even likely, that an international consensus can develop for such an identifier in advance of the implementation date for the rule. And that's the optimum outcome. That's what we hope for. The rule provides for us to do it our own way if we have to.
This registration authority, do you have an opinion whether it should be here or abroad and who would regulate it?
The way ISO is structured, it is international protocol system, and it has all national organizations, bodies, whether it is more quasi-government organization or more trade association that implements those data protocols. And it's not only for financial products. Your even tire is going to have some kind of ISO code that is agreed by all jurisdictions. So the way we are trying to approach it is to create a system that will be workable for ISO protocol in general and for individual jurisdiction in particular to move ahead with some kind of structure. And we had negotiations, consultations with European Bank and European Commission on that, and they're trying to move a push from their regulatory perspective to facilitate the development. And the way we see it right now, it's not a matter of regulators prescribing it, but more leveraging on industry infrastructure and industry developments right now and put it in some unified consensus framework that everybody can use it.
One of the issues we've had, and we've put, I think, 2 rulemakings thus far, is the ownership and control rule in the future space. And we've put out proposals that come back. We've shifted them and put some and republished some new proposals, and we received a lot of feedback about the cost of this and concern. Now, Ananda, our Director of Clearing and Intermediate Oversight, did say that it was his view that we can't have a bifurcated system for margining. Can we have a bifurcated system for futures and swaps in terms of a universal identifier?
Well, I think we added some language to the preamble to the rule precisely to address this issue. This is really separate from the whole ownership and control issue. That's about accounts. It would be retrospective in some extent about the data, and it would require people to reach for data in multiple places. This is just about identifying the legal entity that's a counterparty to the swap. It's really a very separate thing, in some ways a simpler thing. It only would be done going forward. You go get an identifier, and then you have it. You don't have to hunt for data anywhere else.
This does seem as simple as having my Arlington library card, but I suspect it's a little more difficult than that and a little more costly, correct?
One of the principles we laid out is that this ought to be royalty-free or on a reasonable royalty basis, which is language in an OMB release about this sort of thing. There would need to be a reasonable fee to an entity that comes and says, I want an identifier, because the registration authority has to verify that they are who they say they are. And that verification would have to be, maintained over time. But the principles call for this not to be monetized, for the small cost involved not to be a barrier to use or entry for anyone.
If there are no further questions, then I will call the question on the proposal, staff proposal on data. All those in favor indicate by saying aye. Aye. All those opposed indicate by saying no. The ayes appear to have it. The ayes have it. Thank you very much. You all right without a break, or do you want to break? No. All right. We're going to move on to the third of the data trio. Public reporting post-trade, what Congress laid out in the statute for what has been called real-time reporting, but is related to the reporting of transactions, price and volume, and key terms after the transaction has occurred. So sometimes we call it post-trade transparency. And Tom Leahy from the Division of Market Oversight has been our team lead. Jeff Steiner also from the Division of Market Oversight, Tom quickly, and I think it was a day after he was volunteered for this job, got a deputy, and Rick Schultz, the head of our division. Tom?
Thank you, Mr. Chairman. Thank you, Commissioners. Before I begin, I would like to thank Jeff and my fellow team members for their dedicated and tireless efforts in preparing the proposal that I'm about to present. Today, staff is recommending that the Commission approve a notice of proposed rulemaking to implement new regulations regarding real-time public reporting of swap transaction and pricing data, and new regulations regarding size and public reporting requirements for block trades and large notional swap transactions. This notice of proposed rulemaking reflects consultation with SEC staff and staff of the Board of Governors of the Federal Reserve, as well as meetings with and comments from market participants. The proposed regulations specify who is responsible for reporting and publicly disseminating swap transaction and pricing data, how such reporting and public dissemination may be accomplished, and the data fields to be reported. In addition, the proposed regulations establish the methodology for determining an appropriate minimum block size and establish the time delay for publicly disseminating block trade and large notional swap transaction and pricing data. In drafting these proposed rules, staff took into account the possible effects on liquidity of public disclosure of swap transaction and pricing data. With respect to the real-time public reporting of swap transaction and pricing data, the proposed regulations specify the timing and manner in which parties to a swap should report such data to registered entities. Swap dealers, major swap participants, and end users could satisfy their requirements by transacting on a CEF or DCM. CEFs and DCMs must send such swap transaction and pricing data to a real-time disseminator as soon as technologically practicable. If a swap is transacted off facility, meaning that it is executed bilaterally between two counterparties off of an exchange or CEF, then one party to that swap must report the swap transaction and pricing data to a registered SDR that accepts and publicly disseminates such swap transaction and pricing data in real time as soon as technologically practicable. The proposed rules establish an order of precedence to determine which party to the swap is responsible for reporting. That order is swap dealer, major swap participant, and then end user. If the parties to the swap are of equal rank in this order, then the participants must choose which party would report the data. Swap dealers may make swap transaction and pricing data available to their customers, but must not do so before the transmission of such data to the real-time disseminator. With respect to the real-time public dissemination of swap transaction and pricing data, the proposed regulations specify that registered entities will be responsible for publicly disseminating swap transaction and pricing data in real time. Swap execution facilities and designated contract markets may satisfy the public dissemination requirement by providing such data to a swap data repository that accepts and publicly disseminates such data as soon as technologically practicable. Alternatively, a CEF or DCM may publicly disseminate such data through a third-party service provider. However, the CEF or DCM would not have satisfied its public dissemination requirement until the third-party service provider publicly disseminates such data. CEFs and DCMs may make swap transaction and pricing data available to their market participants, but must not do so before the transmission of such data to the real-time disseminator. Swap transaction and pricing data for off-facility swaps must be provided to a swap data repository that accepts and publicly disseminates such swap transaction and pricing data in real time so that the SDR can disseminate such data to the public. The proposed regulations also specify data fields for the purpose of reporting swap transaction and pricing data to the public. In this regard, the Dodd-Frank Act specifies that price and volume data must be reported. In order to give meaning to the price, certain data fields must be reported. These data fields include, for example, the contract type and subtype, underlying asset or assets, notional size, currency or currencies, start date, payment frequencies, etc. Additionally, the proposed regulations provide guidance and examples relating to the format and manner that such data fields may be publicly disseminated. With respect to block trades and large notional swap transactions, the proposed regulations specify the transaction size that qualifies as a block trade or large notional swap, and the time delay in publicly disseminating the swap transaction pricing data. The proposed regulations define a block trade as a swap that has the following criteria. It is made available for trading on a CEF or a DCM. It occurs off the CEF's or DCM's trading system or platform pursuant to the CEF or DCM rules. It has a size that is consistent with the appropriate minimum block size requirements in the proposed regulations, and it is reported to the CEF or DCM in accordance with the CEF or DCM rules and procedures and subject to the appropriate time delay in the proposed regulations. Similarly, the proposed regulations define a large notional swap as a swap that has the following criteria. It is not available for trading or execution on a CEF or a DCM. It has a notional or principal amount that is consistent with the appropriate minimum size requirements in the proposed regulations, and it is reported in accordance with the appropriate time delay in the proposed regulations. To qualify as a block trade or large notional swap, the transaction size must be at least as large as the greater of either 5 times the greatest of the mean, median, and mode of transaction sizes for similar swaps, or among the largest 5% of transaction sizes in similar swaps. Under the proposed regulations, SDRs would make this calculation and publish it on their website using transaction data from the prior calendar year. CEFs and DCMs would then set the minimum block trade size for particular contracts that they list based on the calculations published by the SDR. The proposed regulations also specify a delay of 15 minutes in publicly disseminating swap transaction and pricing data for block trades and large notional transactions and standardized contracts. The proposal seeks comment from the public regarding appropriate time delays for large notional customized swap transactions. This proposed regulation will be open for a 60-day public comment period. That concludes my remarks. My colleagues and I are happy to answer any questions.
Tom and team, I thank you. With that, I'll entertain a motion on the staff recommendation on real-time reporting.
So moved.
I support the proposed rulemaking to implement real-time public reporting that congressional directed us to. I think the rule does fulfill the Congress's direction to bring public transparency to the entire swaps market. This is both the standardized market and the customized swap market, and that is what Congress has directed us to do. This post-trade transparency will enhance price discovery and liquidity. I know that many market users might take the other side of that, but I truly believe that post-trade transparency and the economic studies over many markets shows that it enhances both price discovery and liquidity, while, as Congress has asked us to do, ensuring anonymity of the participants and protections for large trades in appropriate cases, or what's often known as block trades. Per Congress's direction, the proposal requires real-time reporting for swap transactions and pricing data to occur as soon as technologically practicable. Those are the words of the statute. We're not making them up in a rule. They're the words of the statute. For trades that are under the size of a block trade or other than trades that are large notional size or block trades. Congress mandated that these trades be reported without delays, or in their words, as soon as technologically practicable, regardless of whether they're standardized or customized. And so we've used the statutory provisions and recommended that. With regard to block trades or trades of large notional size, the proposed rule includes 2 important features, and I just want to chat about each of them and why I support the rule. The first is a time delay. A time delay, and the second is a method on how to report large trades. But let me start with the time delay. For standard transactions, those that might be, in essence, on a swap execution facility, on a designated contract market, the proposal includes a 15-minute delay on standardized blocks. This compares to the futures marketplace, which is currently 5-minute delay, and the equities marketplace, which is actually even shorter than the 5-minute delay. With regard to customized trades of large notional size, think of the ones that are not clearable, they're not at a clearinghouse, they're not at a CEF or a DCM. For those, what I'll call customized trades, the proposal takes really just asks a series of questions. Whether a 15-minute delay would be appropriate for the interest rate, currency, and other financial swaps markets, and what delays may be appropriate for customized large trades in physical commodities. So there's, in essence, 4 different categories one might think of. The non-block standardized trades, Congress has said that's as soon as technologically practicable. We're just following statute. The customized non-block trades, we're following statute. That, too, is just as soon as technologically practicable. But on the 2 categories of larger trades, block trades which are standardized enough to be on a CEF or DCM and so forth, we're recommending a 15-minute delay. And then on the truly customized blocks, we're asking a series of questions of starting with, should it be the 15 minutes on the financials, but just a series of questions. The second important feature with regard to block trades or trades of large notional size is a reporting methodology that says, regardless of the size, if it gets over $250 million of notional amount, the only thing that the report would say is $250 million plus. This could be on a $260 million trade, a $1 billion trade, a $3 billion trade. It would just say $250 million and have a little plus. This, I think, both helps protect anonymity, but also helps to promote liquidity in these large trades, whether they be customized or on a standard marketplace. The proposal on real-time reporting includes the methods by which to calculate what a block trade is, and we're going to look forward to a lot of public comment on this, but they are a methodology that is across markets. The thought being that there not be regulatory arbitrage, that there would be one swap execution facility that have different block sizes than another swap execution facility. And that, in essence, that trading platforms might compete and arbitrage on darkness. Darkness is when you don't have to report something. So the thinking here, and this will relate to ultimately what we have in the swap execution facility area, but that there's computation done by the swap data repository once a year based on the data across the entire marketplace. And there's various formulas, as Tom Leahy laid out, with regard to that. The proposal includes an initial implementation date of January of 2012 so that the swap data repositories can do those initial calculations, and then each January thereafter would do the calculations. But it also provides market participants, whether they be swap execution facilities or swap dealers, time to adjust, and though the statute ultimately, I guess, takes effect next July 15th, this gives additional time for everybody to move forward. Real-time post-trade reporting is critical to promoting market integrity, and yes, Commissioner Mallieu, you're right, I am passionate about it because I think it helps the economy, and I think it helps all investors and hedgers and end users. It does shift some of the information advantage from Wall Street, which I proudly served in for 18 years. But I will tell you, if I might, Wall Street benefits by information advantages, and they will send us hundreds, if not thousands, of comments that we're hurting liquidity. And I feel to my core we're helping liquidity, and we're helping those small municipal governments, those small companies that will get a chance to see where the pricing is for these swaps. So I think Congress has said on the smaller trades, it's as soon as technologically practicable, and I think Tom and his team has put that in this rule. For the larger trades, there will be a time delay of 15 minutes. Wall Street can hedge their first-order risk on the standard trades and probably their second and third-order risk. But they'll tell us why they can't and why they might need days or weeks. And that information advantage, if we let it be days or weeks, will stay with Wall Street. And I think they absolutely should comment on this. But I think that we've balanced the considerations here also with saying anything over $250 million will just have a plus sign next to it. On the customized blocks, we ask a series of questions, because I think that is more challenging, particularly in the physical commodity area. If it's a customized block trade of natural gas or jet fuel, or I don't know that there are large trades like this in the agricultural space, but I think it's appropriate to consider what time delays on those customized blocks are appropriate, and I look forward to the comments from the public. So I don't have any questions for you, Tom. I just thought I'd say why I'm so passionate to help the American public get lightness where we've had so much darkness to date. Commissioner Dunn.
Thank you, Mr. Chairman. In the course of this meeting today, you've referred to these as the 3 data regulations, and I think 3D is an appropriate analogy here. I think getting these together, things should pop out to us. They should pop out to the public as to what's taking place. I associate myself with your comments on getting that information out. I'm hopeful that we have coordinated this well enough with our sister agency at the SEC and our agencies internationally so that we do see a nice crisp pop out and not a blur of many different colors. So I am looking really forward to seeing the comments that we receive on this particular one.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. And thank this team for all of your hard work on this issue area. I think all of these different rulemakings on data kind of intersect with each other, so I have a number of different concerns, but I'll start with the one that sort of intersects with the SDR proposal, and it's with regard to the real-time disseminators. So we define a real-time disseminator as either an SDR or a third-party vendor, and we talk about if the SDR is not going to be the entity to report to the public in real time, that the third-party vendor is able to do that, or if a SDR does not exist. What if there's not a third-party vendor that is willing to take the data? Is there any sort of contemplation, like the statute says, that the data would then come to the Commission?
Yeah, that's. I think that would be the default, but we do ask questions on that topic in this proposed rulemaking.
And do you think that the third-party vendors should have obligations with regard, an SDR has obligations, but we don't really talk about what kind of obligations or registration that a third-party vendor would have?
At this time, the hook would be on the either the registered entity or the registrant to ensure that the data is reported in real time if they choose to report through a third-party service provider.
And so, how does that happen? If you think about that, I tried to think through that. If you're a counterparty and you're sending your data in, but you're responsible for making sure that the third-party vendor reports it in real time, how do you do that?
Well, what I would expect is that it would be a contractual arrangement, that the owner of the data would, in essence, enter into a contract with the third-party data, perhaps selling that data to the third party who would package it up and with others perhaps and sell to market participants. But that's one potential model. But again, the registered entities and the registrants would be on the hook to ensure that it happens.
And I don't know if that's fundamentally different from when a DCM, for example, contracts out with NFA or another party for, say, surveillance, some self-regulatory functions. The DCM ultimately is responsible that the core principles are carried out.
Another part of the SDR proposal that I think intersects with this one is where the SDR talks about the time delays that are required for reporting the SDR reports. and they have these 15, 30 minutes, and then depending on whether or not the trade is electronically executed, electronically confirmed, why wouldn't those timeframes and that framework be relevant to what we're doing with real time? Why are they different?
Well, I think they are relevant to some extent. I think they provide backstops. There's two different data sets, although the real-time data set may be a subset of the broader data set that is provided for record-keeping purposes. But our feeling is that if a registered entity or a registrant can provide the data to the SDR within those time frames, they can certainly provide the real-time data, or what we need to be disseminated to the public, certainly within that time frame. We did not specify backstops for these because we recognize that different entities may have different abilities to report. So we decided not to include those. But we do have, like I said, we do have those other backstops. We can look, since all of these transactions will be time-stamped, the Commission can go in and see how long it is taking from the time of execution to the time of reporting. We can compare with other entities of similar size, similar prestige, whatever variables we decide are appropriate, and to determine whether or not reporting is occurring in a timely fashion as soon as technologically practicable.
Can you also talk through on the difference between what we're looking at in large notional swaps, in customized versus standardized, and how we have taken into account the liquidity in those markets? Because we do draw this line in this proposal, although we talk about the differences between customized and standardized. We don't actually define those in the rule, but we've drawn this line, and how those may be different, or if there is a difference that exists, and if we considered the liquidity in those different markets.
I think the easiest way to differentiate is whether or not the contract is available for trading on a CEF or a DCM. Those contracts are going to be the standardized contracts. If they're not available for trading on a CEF or a DCM, it's most likely that those are going to be the customized contracts. We do differentiate, and again, so the standardized contracts have that 15-minute time delay for blocks. It's 15 minutes because, as the Chairman said, we believe that market participants should be able to lay off any risk that market makers would take or swap dealers would take in assuming that risk from others. It's the highly customized ones where there may be other forms of risk that are associated with those, and there may be embedded options, for example. It may be a more specialized or more specific commodity definition. The risk associated with those might be more difficult to lay off, and so that's why we're asking questions to determine what is an appropriate time delay for those.
Okay. And my last line of questioning is, again, on the consistency with other regulators. Do we know what the SEC is proposing today? If you could walk through that with us.
Well, I mean, we don't know. I don't know exactly where they're ending up today, if there are any changes. But like us, they say that it's as soon as technologically practicable. I believe that they have a backstop of 15 minutes for all trades, regardless of the counterparty. And as far as block trades, they're reporting for block trades. The last I had heard was that they will report everything as soon as technologically practicable with the exception of the notional amount of the trade, which would then be reported at the end of the day. Again, their markets are different, so you have to take that into account.
Thank you. I think that one of the issues that I know we added a number of questions on is with regard to the asset class and how we consider the difference in potentially the liquidity in each of the different asset classes. I think that that's one of the areas that the European Commission certainly has differentiated their recommendations on, is depending on the asset class. So I guess I would just suggest that I would hope that we would continue to try to be consistent with them on, if they're going to make differentiations based on asset class, that we would consider that as well.
Can I just, I'm sure that the Fourth Estate will report on what we do and the SEC does and so forth, but we both have the same statutory provisions, as soon as technologically practicable, right?
That's correct.
We both have block and determine what blocks are.
That's correct.
Though we don't have what you call backstop, we're both saying you have to do these smaller trades as soon as technologically practicable.
That's right. I mean, the backstop is, you have to report your trades as soon as technologically practicable.
So they might be more restrictive because they have a deadline. But and isn't it right that if it's electronic, when it's on a swap execution facility, that's probably pretty darn fast as soon as technologically practicable in both both regimes, whether it's the SECs and IRS. If it's electronic, it's on an execution platform, it's probably pretty fast.
That's right. And we understand that from market participants and our roundtable discussion that that's the case.
And then obviously if we go all the way to the other spectrum, if it's an end user to end user, and again, we think that's a very small part of the market, and they're just doing it on the telephone, and they're not, and it's customized, some very customized, I don't know, an electricity market or something. As soon as technologically practicable might mean something very different.
Mm-hmm. Yes, that's right.
Okay, thanks. Commissioner Chilton.
Just reading one of the comment letters that came in October, and it's Bank of America, Barclays, Citi, some others, Morgan, HSBC. And they're sort of getting at this whole issue of block trades, and it's one of the things they get to, and whether or not they do have inadequate time to lay off risk. And I'm looking forward to the comment letters, because if they can't, ultimately consumers pay for it. So that doesn't make me very happy. So I think it's a balancing act that we need to get in here. They need to be able to lay off their risk and effectively hedge. So I look forward to seeing what they have to say. I think you all have done a good job in putting this forward. Thank you.
Thank you, Commissioner Chilton. I think that I'm going to maybe disagree with Tom. You might not lay off every single risk, because you may either have a basis risk. You could do a $1 billion 14-year interest rate swap and decide to hedge it with 5, 10, and 30-year. And, you might still have some what's called basis risk between the 14-year point in the curve and the 5 and 10 and 30. Or even in a very liquid oil markets, you might have a locational basis risk. It might be crude oil, but delivered to a different place. So it's that debate. But most risk management of Wall Street, would want to try to hedge their first order and maybe their second and third order risk, and they'll still have, basis risk they could be managing for some time. Commissioner Amaya.
Mr. Chairman, you indicated that Wall Street dealers would use this liquidity argument to their advantage.
They might or might not.
Well, all I can say is that we've been inundated already. I think Commissioner Chilton has mentioned the buy side has also mentioned this, and ostensibly we're here to, transparency is argued to be protecting and advantaging the buy side, and so they have mentioned liquidity here, and so. Tom, you mentioned in your opening statement you've looked at liquidity, but in this rulemaking I cannot find an economic analysis, any analysis of the liquidity issue. You want to elaborate on that? In fact, I think in my opening statement I referenced footnote 74, 72 that that said, we haven't really looked at it, and, it could change, and the more we know, then we'll adjust our rules.
This rulemaking is going to, well, Dodd-Frank fundamentally changes how the over-the-counter markets work. We don't have data specifically for the swap
Let me
market.
ask you on that. Do you think it's going to change the way it works or change the way we regulate? I mean, there's still going to be illiquid products, and there's still going to be thinly traded. How does it change that?
It's going to move more more of these swaps onto CEFs and DCMs. I don't think it'll change it in that respect. That's actually an argument for a different rulemaking. But I think it's going to.
I thought they should always be brought together.
Okay, but that'll bring the pre-trade transparency. This is the post-trade. But where I was going with this is that we don't have the data because this hasn't been tried before, specifically for swaps. At our roundtable and in conversations with certain market participants, academics, the argument was made with respect to trace. That trace, if you require reporting of over-the-counter fixed income transactions, that's going to harm liquidity. And one of our roundtable participants, a former chief economist at the SEC, flat out stated there is no evidence that it harmed liquidity. And in fact, the evidence points to the opposite. So we had to use analogs like that. There is no specific data with respect to swaps and post-trade transparency. It doesn't exist at this time.
So the statute says we have to consider it. And going forward, how will we consider it?
Going forward, we will have that data, and we can analyze that data and determine whether or not we're better off having post-trade transparency. But until we have the data, until we try it, we can't. There is no laboratory.
We established in the previous panel that the swap is owned by the parties that transact on it. Do we limit swap owners, therefore, the ability to sell or distribute information regarding the trade prior to sending it to a SDR?
We are mostly silent on that. We have implicitly stated that, and I want to emphasize implicit, that the owners of the data would be the market participants if it's off facility or the facility itself, by allowing them to provide that data to, if it's a swap dealer, to its customer base, or if it's a swap, or if it's a CEF or a DCM, provide that data to its market participants, its own market participants, whether that's a bonus for working with us or whether it's sold, that would be up to the owner of that data.
But there is no limitation on when they send it, how they send it, if they sell it at all.
The limitation is that they cannot do that earlier than they report it to the SDR. We expect that there would be at least some delay from the time that it's sent to the SDR until the SDR is able to publicly disseminate that data.
That's sending it to the SDR for the purposes of real-time dissemination, or in the case of a swap market, a CEF or a DCM, it may be to a third-party service provider that real-time disseminates.
When does it count that you've complied with the Act to report? When it transacts on a screen, or when it actually is sent and disseminated by an SDR?
You've complied when you have sent it to the real-time disseminator, whether it's the SDR or a third party. That's the point at which we believe you have complied.
What if it's on a CEF that's this transparent mechanism that you've talked about?
That may not be. That may not qualify. It depends on how open it is. It would seem to me that should be a way to comply, and perhaps we can receive comments on that. If it is a fully publicly available website and you have that data out there, it would seem to me that should be consistent with the Act.
we have a couple of new terms introduced in the latest revision of this, the standardized swap trade and this customized large notional trade. They're not defined. They're discussed in the preamble, but they're not defined. You want to elaborate on them?
The standardized are those that are available for trading on a SEF or a DCM. Whether they are traded on a SEF or a DCM is not material. I mean, those contracts could be traded off of a SEF or a DCM pursuant to the end user exception.
Okay, so it's on exchange or on SEF or DCM or off an exchange or DCM.
Well, again, if it's eligible to be traded on a SEF or a DCM, in that respect, like you could have an end user exception, a transaction pursuant to the end user exception, which the contract that they're trading, the swap that they're trading, is essentially standardized. It could have been traded on a SEF or a DCM.
Does it have to be identical, or does it have to be close?
I would say it has to be close. I don't think it needs to be identical. And now there are ways that you can make it different, and we include those as data fields. For example, if an entity wanted to include a worthless embedded option, we would have visibility of that, and that would not be a sufficient reason for it to be non-standardized, at least in my opinion. So if it's eligible to be traded on a SEF or a DCM, we would view that as standardized. If it's not, it would be customized.
Just to add some of the statutory language behind it, the standardized ones, we're looking at Section 2A 13C, Romanet 1 and Romanet 4. And as far as the customized transactions, it would be Romanets 2 and 3.
I thank the staff, and I thank my fellow commissioners, because this one's a very important one, and I think we do all share the view to bring transparency to markets is a good thing. We might have a little difference on, and the public's going to help us out tremendously, a lot. But if there are no further questions, and the motion having been seconded, all those in favor indicate by saying aye. Aye. All those opposed indicate by saying nay.
Nay.
Nay. The ayes appears to have it. The ayes have it, and the motion carries. I'm also at this point going to ask for unanimous consent to allow staff to make minor technical corrections to the documents voted on today prior to sending them to the Federal Register, including some numerical corrections in the PRA. PRA means Paperwork Reduction Act estimates. And I guess I can make that motion, so I'll make that motion for unanimous consent. Are there any objections? Not hearing any objections, that carries. I had said that I'd just say a few words on schedule, and I think Commissioner Malia raised this. It was a good question. As you all know, we've identified 30 topic areas, and with the SEC, and it's been a tremendous collaboration and partnership with them, we laid out internally a schedule through the middle of December, always recognizing flexibility. I say publicly we're all human, but I mean flexibility that some would be taken up in January, but at least we kept our feet to the fire through December. We currently have a meeting for December 1st scheduled. I'm losing track if we've put in the Federal Register, but we do have 2 dates in December that we've all can come together on. If I wasn't trying to make news here and say the dates, but they are calendar. They're 2 very specific dates. And some things will move to January. In terms of the topics themselves, on definitions, there's 2 major rules, entity definitions and product definitions. And Cyrus keeps telling me that we're in good coordination with the SEC. We're looking to do the entity definition on the December 1st. I suspect product definition will be one of those other 2 dates. I think the last date in December we have is December 16th, and then thankfully people can go to their holidays and everything. So that product definition one would probably be later. In terms of other things that we have in the I'm just thinking by division, but in the Division of Market Oversight, we have a number of rules, but the main two pieces are designated contract markets and swap execution facilities. And the designated contract market, I think, is on our next meeting. I think that's December 1st. And the swap execution facility, I believe, is in the next one. And I can't remember the date, but it's, what's that, David? The 9th, maybe the 9th of December. So it's almost, but I think the swap execution one is on the 9th. And those are the two main things in the Division of Market Oversight. In the Division of Clearing, we have what is the second batch of both the internal business conduct standards and the designated contract market, DCO standards, and those are calendared for December 1st. So the second batch, which is largely about record keeping, reporting, administrative matters, and so forth, the risk management batch of both internal business conduct and the risk management batch for the clearinghouses, I think, is that December 16th meeting. Again, all of this can move. It could change. I mean, we have a lot of moving parts, but those are the main pieces, the risk management piece being the latter one, and the more administrative record-keeping piece being December 1st on both internal business conduct and on the clearinghouses. The end-user exception, the commercial end-user exception, George's team, and it's in the Office of General Counsel, but I think that's in that middle meeting in December. But whether it actually ends up on December 9th or December 16th, but that's a very important one, and that's what we've been looking at trying to do. And then position limits. Rick will tell us when he's going to be able to have it in front of us. But that's going to be one of these December meetings. I mean, but this position limits, I'm trying to think, what have I left out? So the things that are probably going to be later is if we do a roundtable on capital and margin, which I'm committed to, and I think it's a good idea. We'll do that as soon as staff can do it in early December. I think that means capital margin will be a January rulemaking. I think that's just appropriate. And though the public would like to know where we're coming out, I think that will add a little bit more time. We have a joint rule with the SEC, which is not related to derivatives, which is related to hedge funds and the disclosure on hedge funds, and that has to be joint. And I think that's going to be calendared for the middle of January, and we're really mostly working with the SEC. They're taking the lead on that, but I think that's probably, it's sort of not specifically related to derivatives. So I don't feel we've slipped on that one. And then we've also put out an advance notice of proposed rulemaking on another topic, agricultural swaps, and we've just been getting the public comments in. So inevitably, I mean, the actual proposal there, whether staff can get that together for us by mid-January, which would be terrific if they can. But I think the hedge fund work, the capital margin, because of the good suggestion to have a roundtable, and because we did an ANPR on the agricultural area, it was not a mandated rule, but the discretionary rule on disruptive trading practices we planned, and we put out an ANPR, and of course when those comments all come back in, then staff will work with those comments, and we'll see when we can calendar that. If I'm missing, Dan, am I missing any of the big ones? Oh, thank you. The rule for external business conduct, which is very important, it's being run out of the Division of Enforcement. That's right, I forgot one division. Will be either this, I can't remember whether it's the second or third meeting in December. It's not December 1st, but it'll be either the second. So I think December 1st is a full meeting, so that one might be the second or third meeting, or at least tentatively. These are not fixed dates. I say to our friends from the Fourth Estate, we're not only human, but we're trying to coordinate and do this right in all the comments. Is that, Commissioner O'Malley, were there other?
The only question I just asked staff was portfolio margining.
Well, portfolio margining, Thank you. Portfolio margining, some of which we've taken up even today in the midst of the notice of proposed rulemaking for non-cleared swaps, and there's some technical parts of portfolio margining that will be taken up in the risk management rules for clearinghouses. But there's still the bigger issue with the SEC that has to be done jointly. I don't think we'll be able to do that in December. From Cyrus, yeah.
And that's not a 360-day.
Right. So we'll take up the things that we can and need to do in clearing. I believe, as you do, Commissioner Malloy, that we really need to do this. But I don't. It's not calendared for December. But I'm associating my remarks with you, Commissioner. If there's no other further business, I've just probably gotten our press secretary, Scott Schneider, upset with me by doing all of that transparently, but it's there. Then I will entertain a motion to adjourn the meeting.
So moved.
Second.
All in favor?
Aye.
Any opposed? It appears the ayes have it. The ayes have it. The meeting is adjourned.